Get going this morning? Good morning. Wow, I guess we'll echo in here. Welcome to CLE by the Sea, sponsored by the State Bar of Arizona. For those of you who either don't know me or wonder where the white-haired man went, I am Dale Sheehan of Sheehan Walker, and will be your moderator this week. A few housekeeping items before we get going. They are attempting to turn down the air conditioning in here. I think I feel it coming on. I have offered to trade it for a smaller room with more air, but we will see. But hopefully it will cool down shortly. There was one handout that I'm actually there were two handouts. There's the big group of materials, and then there's a supplementary sheet for this one. Hopefully everybody grabbed both of those when they came in this morning. Our first panel is the Bankruptcy Legends panel, with moderated by Judge Redfield T. Baum, Tom Baum, to all of his friends, which is just about everyone in the District of Arizona. Joining him is Lowell Rothschild from the Mesh, Clark and Rothschild firm, and Jerry Smith, who I always think of as Lewis and Roca, but he has been practicing with his son for the past several years now as Smith and Smith. They are going to have a presentation on kind of the history of bankruptcy practice, the characters, the events, some of the more interesting cases, to give us some perspective, and then also hopefully share with us where they see things going forward, as all of our sitting judges are set to retire, and it's going to be a time of transition in the district. So without further ado, let me please join me in welcoming our panel.
Thank you all. When I was called and told I was going to be the moderator for this program, I realized instantly that my role was to be Mr. Irrelevant, because the two gentlemen to my left, they'll probably kick me for saying this, but I think we have almost 120 years of experience in the bankruptcy world, covering the national level, the enactment of the 1978 Bankruptcy Code, and probably every case, certainly in the Arizona and a lot beyond, that you've heard about from the 50s, the 60s, and so on. So without further ado, I'm going to hand the microphone off to the gentleman to my left, Lowell Rothschild. And I just want to say this about him. It's in the materials, but in 1955, the State Bar of Arizona had to form a bankruptcy section because the filings had exploded from 100 cases in 1953 to 500 cases in 1955. And there were then 5 members of the founding section of the Bankruptcy Code, one of them being Lowell Rothschild. Lowell?
I don't know where to start, because whenever I get around...
The 1898
Can you hear us? Can you? I was going to start at the 1898 Act. I asked that we make a preliminary statement. In the first induction of the American College of Bankruptcy, the speaker was Jerry Smith, and he made the comment that reorganization and bankruptcy was an element of capitalism, and it stuck with me. It's 21 years ago in terms of the things that we do. I've been very lucky. I've had an opportunity to be healthy and watch the practice develop for really, I practiced 60 years, which is an anomaly. I'm not suggesting that you all follow my lead, because I think it's very different now than when I practiced. We had no technology. We didn't have to answer. My practice generally was and has been a debtor's practice, so I spent a lot of time hiding from creditors and slowing the process down so that the value of their money became less and less, which was one of the strategies. And then along came an entirely different crew of attorneys. And my judgment is that from Arizona, in Arizona, where we had 5 or 6 or 7 of us, Tony Jones in Phoenix, Henry Jacobowitz, myself, a man by the name of Ed Scruggs. I was a beginner. Ed became a Supreme Court judge. And we were served in the court by a referee, Stanley, and you'll look at the list, and later on I'm going to talk about the genesis of the judges and how many had got there and what, quote, the system was, whether some of you think it was a system or not. So it was very informal, and referee German would, he was an itinerant judge. He would come to Tucson when it was convenient. I've gone to Miami Globe in a little courtroom there, and he went around the state, and he did it for 19, 20 years. To my surprise, when I start looking at this to tell this story, we've had referees since 1912, which is coincidental, and you'll see it in here, with the establishment of the state. In 1903, before that, Arizona had 2 bankruptcies, and Nevada had 4. And you can get all these statistics, which become kind of irrelevant by now. But the bankruptcy practice, in my view of it, basically grew as the state grew. And the quality of the lawyers who did it improved as we went along. So that I think now that the level of professionalism with the attorneys that practice in Arizona is very, very good, well trained. I'm going to make a couple personal comments. I attribute that, and by the way, you don't have to like these people or not, but I attributed a lot of that to 2 men, and I told that at the bar. One to Jerry Smith, who brought a certain level, and when you hear what he was involved in, we even learned last night things they were involved in that I never knew throughout the United States. So I have to tell you, Jerry really, really directed a major part of the United States Bankruptcy Code and since '78 through his personal interest and training, and also did that for the lawyers of Arizona. I personally felt that way about John Dawson. All 6'5" of them, 200 or 300 pounds of him. I like to be able to call him at 11 o'clock at night when he was working.
He was always there.
Which doesn't say much about me, but and I had a good relationship with him. We fought a lot. We screamed at each other. Not really screamed at each other. We fought a lot and did over matters. But in my case, he was tough, and he worked hard, and he was totally committed, and he created a progeny of I think, outstanding lawyers that are in all kinds of firms. A couple of them are sitting here in this room. So the level of the practice came from being the people who financed the retail merchants to a very sophisticated group of lawyers who developed a practice that I personally am proud to be part of. You know, the whole history of who was the bankruptcy lawyers, where it was Sullivan and Cromwell and all of these people didn't touch their hands. The outliers became bankruptcy lawyers. And so Judge Baum, Tom's going to talk to you a little bit about that. So as you're doing this, you should have a lot to be proud of. I've looked at it at 60 years. I know most of you, and I'm very impressed. Of course, there have been different waves of interesting things. What do we have? 1, 2, 3, 4 women here. And when I started practicing, there was Zippo women. They didn't have an opportunity. It was a men's club. And I'm going to tell a little side story because, unfortunately, you're on video, but I'm going to tell it. I was on the first selection committee that really became a commission. Historically, the judges were picked by the chief judge, and they were obviously very political. notwithstanding the so-called objectivity. May my friend Mo Allison rest in peace, but it wasn't inconvenient that Marcia was a close friend of Dennis's wife. And the time came up, and when they decided to pick a judge for Tucson, and Mo had been in an industrial commission, a lawyer, and had been honored by the industrial commission, did all kinds of things, created the law that had to do with heart problems in industrial commission, the Supreme Court law. Then he got involved in that and became the judge.
Let me interject for those of you who don't know. Dennis is Dennis
No, I'm sorry.
DeConcini, former United States Senator, one of the authors of the Bankruptcy Code and a great friend of the federal court. So Senator DeConcini called then Chief Judge Mickey and said, it would be really nice if Lawrence, Mo Allison, was the next bankruptcy judge.
Were you Mickey's clerk at the time? You were gone by that, weren't you, Michael? You were gone by then. And so subsequently they had the various commissions, and I thought that was, and we'll talk fully about that, I thought that brought it to a really reasonably open level. I'm using my words very carefully in the sense that people had an opportunity to at least be exposed to the commission. We've had 5 commissions now. I've sat on it, when Boswell sat on it, McGrath sat on it, and those of you who practiced a long time, I'm sorry if you didn't like some of our recommendations.
Well, they obviously made some mistakes because I'm sitting up there.
Well, as somebody said to me recently, which I kind of resented a little bit, he said, that's your cross to bear, and they're a friend. At any rate, so those of you, and it's a small group here, I think I'm obviously biased that the practice of bankruptcy law at the level it is in Arizona, and we'll talk about major cases, is in the 60 years gone from a 2 to a 10. And you're to be confident. We were talking about my friend Skip Wood, who I never agreed with on anything. Well, that's not quite true. Who had devoted a good portion of his practice to people who couldn't pay. He did it legal aid. He did it as a practitioner. I always wondered why he never collected any money, but still spends his time living on a sailboat in San Diego. So maybe he didn't tell me the whole story. But the breadth of the practitioners, the breadth of their ability to do the general practice, the business practice, the litigation, is really fascinating. So you should be very proud of what you do and your interest. Dale passed out a sheet prepared by the Federal Center, and we're going to talk about how the events of these years have affected the practice and the nature of the things you do. And many of you, as I look around the room, have been involved in the cases that we're involved in. I'm going to talk to you about a case I was called In Re Yellow Cab. Well, I'm going to tell you right now. A lady gets injured, a yellow cab runs over her, and she loses her leg. And we're in that, and they're just worthless, the whole gang of them. And so this young lawyer shows up. His name is Don Gaffney, and representing her. And we got into this thing, and he was I don't know, he's changed much, but he was pretty snippy and young and full of it. And Bill Scanlon was the judge, and really biased. And the NLRB was involved in it, and that prejudiced Scanlon immediately. And I love the statement which Don probably ran. We went into chambers, and Scanlon said to him, Don, you need to work on this. Lowell's going to have you on a slow boat to China. It's going to take a long time, which didn't set very well with Mr. Gaffney. The end of the story is, whatever the ruling was, it was appealed. And really, Don's participation later on, by the way, the woman received, I think, about $100,000, and Strike Lang waived their fee. Now, I'm telling you publicly that. So we go to this appeal, and Salerno shows up. Gaffney doesn't show up. But Salerno showed up to make the argument. And I get up, and Herb Katz, who had been the San Diego judge and was the head of the BAP, I get up, and he turns his back on me. He totally turns around with his papers and never saw me, never heard my argument, never did anything. They gave me a clue I'd lost. And thereafter we settled. So we're going to talk about incidents in a number of the cases you all have been involved in, tell you some of our reaction. But more importantly, the star and the person who really created a living for all of you, and it was able to help a lot of people because of his philosophy, is my friend Jerry Smith. It was interesting. When I talk about Jerry, I talk about him as a Kansas farmer boy. Well, I learned last night he never lived on a farm. He lived in some city, went to New York City, got infected by Larry King and all of those people who were writing the act, and then ultimately he has been the modern Larry King and the modern Frank Kennedy.
Jerry, before you make your opening statement, I want to tell all of you a little something I've learned about Jerry Smith over the years. As a lawyer in Arizona, I knew Jerry was the godfather of bankruptcy in Arizona. But what I learned after I went on the bench and had a chance to sit in a number of the other jurisdictions in the Ninth Circuit and go to meetings and conferences and places all over the country, Jerry started to become the Lone Ranger to me. And if you remember the end of the Lone Ranger TV series, those of you who are old enough anyway, they would always end by saying, who was that masked man? He rode in, solved some vicious problem, and rode out every time. And that was the concluding phrase. And I started to think of Jerry as not the masked man, but who is that man? Because I could go to Wisconsin and do something with Bob Martin. I could go to the East Coast, to New York, Charleston, Miami, Atlanta, you name it, and everybody would say, oh, you know Jerry Smith. Jerry Smith is the guy. Jerry?
First, let me disclaim some of the statements that have been made. I've been totally blown out of proportion, but thank you. I had an extremely fortuitous role in working on the present bankruptcy laws, and I'll get into that a little bit. And it was one that was totally unexpected. I was a commercial litigator in the 60s. I was activated in the Air Guard, Phoenix Air Guard, in 1961, and didn't start practicing until 1962. And I did commercial suretyship litigation. One of my first cases was up in Holbrook, and the visiting judge there was Frank Kennedy, or Frank, senior moment. He was out in the western part of the,
Was he in Kingman at that time?
Yeah, in Kingman.
Yeah.
Frank Gordon.
Yeah, Frank Gordon, and I,
See, some of us old men remember.
right, and I developed a wonderful relationship with him. We tried the cases for the surety company I was defending. Joe McGarry was really the person I worked with primarily at Lewis and Roca. We got into construction matters. So the focus of my early practice was construction litigation, suretyship, and then they got me into foreclosures, of all things. I'm a debtor's attorney, as it turns out later. But I represented Gibraltar Savings and Loan, Southwest Savings and Loan.
All those failures.
Well, every S&L
All
failed in the 80s. But in any event, you'll see if you get into that area that some of the appellate cases that resolved some of the issues in the early days were ones that I handled in the trial court. For example, the question of whether the undispersed construction proceeds could be reached by the lien claimants who otherwise weren't going to get paid. California had done that, but our Supreme Court ruled that no, that was inappropriate. That was there for the lender's protection, and things have changed over the years. But in any event, I did that type of litigation, and then I got a call and I won't spend long on this, from Charles Seligson, who I had become close to at New York University, where I went to law school. Charles taught the federal jurisdiction course in the evenings as an adjunct professor because of his practice with Morris. It was Morris and Seligson then, and they represent Pepsi-Cola, for example. It was a small firm. We would go out in the village and have supper at night, and he knew these little places were almost like someone's living room and dining room were there. So it was, we were close. He was from the south, southeast, I think South Carolina, as I recall. And he really did like the New York environment, and he loved teaching, he loved students. In any event, I got a call from him, and he wondered if I would like to become involved with the National Bankruptcy Conference. This is an organization that was created in 1933 and 34, really at the direction of the Congress. This was a group of self-anointed experts that were working on the legislation that was being introduced in the New Deal days, and really looking at it carefully. They were the leading experts in the country. There were only 8 or 10, eventually it was 20. But they were asked by the Congress to form an organization, and it became known as the National Bankruptcy Conference, to advise Congress. Congress wanted an independent group of people that had no axe to grind. Many of them were academics. So they worked throughout the period through 38 and then continued on thereafter. And there's quite a bit of material in the materials that you have relating to the National Bankruptcy Conference. Well, this was in 1970 that I was asked if I'd be interested. And I said, I don't know what it is. Can you tell me what it is? And he did, and I said, yes, I'm interested. They would meet in Washington, D.C., and then if they needed 2 meetings a year, they'd have another meeting somewhere else in the country, often in Texas, sometimes in other venues. But they would take everything that had come to their attention, and they had various committees, and they would work on it throughout the year and then present a paper at the conference's meeting, if it was an annual meeting, at the annual meeting. And the conference then would either buy it after making changes or say, no, we don't think this will fly. But a lot of the suggestions over the years have come from that organization. In any event, I said yes. So I ended up being nominated by Pete Lasseau at the University of Texas, who might have been, but for some disagreement, I think primarily with Harold Marsh, as I recall, the reporter rather than Frank Kennedy. And that delayed the startup of the commission, and I'll come to the commission's part of this shortly. In any event, the next thing that happens is I get a call. Well, in the meantime, I had met Vern Countryman. Vern, during the McCarthy era, got crosswise with some of the people at Yale, where he was an instructor, bankruptcy. He was also co-author of the Collier edition with Professor Moore, and he got primarily crosswise with Moore. And I don't know the details of that, but it must have been bitter because he left there, came out to the University of New Mexico, and was teaching out there. And John Frank in our firm had clerked at the same time that he had. John was for Black, and Vern was for Douglas. So I met him and talked him into going fishing with me down at Rocky Point, Puerto Penasco. In the early days, that was great fishing. We'd go out to 22 Mile Reef and catch wonderful grouper and pinto. And Vern came down, we drove down, and we were out in the boat. And my friend Bill Hammer, who had Messenger Printing back in the 80s before it failed, was on the boat, and he's kind of a colorful character. And Vern was just catching these little rock bass, which we would then use for bait. And towards the end of the day, after we'd caught maybe 20 or 30 pinto, and he'd caught 100 rock bass, little ones, Hammer turned to him and said, "You know, Countryman, I think we're going to name you the master baiter." And Vern actually told that story at one of the National Bankruptcy Conference conventions when there used to be about 60 or 70 people there. And he got a big kick out of that, being known as the masturbator. In any event, I got to know Vern pretty well from those experiences, and I get a call asking if I would be interested. They were apparently having some difficulty getting decent staff at the time to go back to Washington because it didn't pay anything, and it was disruptive. You had to move your family and everything. And they wanted to know if I would be willing to spend a year with the Commission on the Bankruptcy Laws. This was after the first year had been spent. Now, this was the commission that was created really as a result of the impetus created by the Brookings Report on the system of bankruptcy, primarily consumer bankruptcy. And Congress authorized the creation of this commission. There were to be, I think, 2 senators, 2 from the House of Representatives, 2 appointed by the Chief Justice, and 2 by the President. I forget the...
Let me interject just so you understand the history. Initially, there were supposed to be 2 bankruptcy referees
Well, here we go.
on that group. And when the Article
Weinfeld?
3 judges found out about that and communicated within Chief Justice Warren Burger, the decision was made that there would be no referees on that group.
And that's true, and this is pervasive, the difficulties. And let me divert for just a second. When I did get back to the commission, and I'll come back to how I got there, I had about 3 months to read everything that had ever been printed from the Library of Congress on bankruptcy, reorganizations, protective committees, all of those materials. And one of the things that I became familiar with was the article, can you all hear me okay, by the way? Was the Thatcher report, and also the Donovan report. Wild Bill Donovan, who later formed the CIA and is famous for other reasons, actually did the study for the Attorney General of the United States, mandated by Congress, to look into the scandals that had occurred in New York City as far as bankruptcy and the connections between referees and those who were handling the cases. They'd file involuntaries, they would end up with the case. It really was a terrible situation. And this is all outlined in the Donovan report. Then Solicitor General Thatcher also is asked by Congress to do an analysis of bankruptcy, and that's a separate document that's available. So I think much of the real distrust and dislike for the system, and in particular the referees, was generated from that. And Ed Weinfeld, who became one of the commissioners on the commission, was from the Southern District of New York, a well-known judge, highly respected, but he really did not like referees. He didn't want them to have any higher status of any nature, and did everything he could. And it was the sole reason, because the commission's ultimate work product contemplates an Article 3 judge for the bankruptcy court. But we couldn't, the commission didn't want to grapple with that because they had Weinfeld, they had Chuck Wiggins, who was a magnificent person. I think he'd probably been in favor of it, but you never know. Article 3 judges stay together pretty well. And we had another, from Chicago, can't think of his name right now. It'll come to me later. So we had 3 Article 3 judges. So that really was the non-starter, even though the National Bankruptcy Conference had recommended that. And you'll see in the materials on Stearns, I think you gave them my paper at the University of Texas. I have attached to that all the resolutions of the National Bankruptcy Conference in 1970, anticipating the work of the Commission on the bankruptcy laws, which had been created, that there should be an Article III judge. Otherwise, you had continuing problems, and it would elevate the court to a level that it was needed. So the NBC has always been strongly in favor of that. It's the Article III judges that, and I don't know if you remember this, but they wouldn't even let bankruptcy referees wear robes initially. It was amazing. There was such prejudice. They didn't want them to look anything like a judge. In any event, part of that came out of the early scandals in New York that were documented by Wild Bill Donovan in the Donovan Report and by Solicitor Thatcher in the Thatcher Report. Well, moving on forward, what happened then, I don't know if you're all familiar with this, but California used to have, and probably still has, a California Financial Lawyers Association that meets once a year, and they have programs at a high level. They were having a program in Alisal in the early part of 1970, inland from, I can't remember where it was, but it's a beautiful place up north ways to have a gathering, and Countryman was there, Harold Marsh was there, who by now was the chairman of the commission, and Frank Kennedy, who was now the executive director, or the director of the commission, and was really going to be the laboring oar. He was a professor from Michigan, had an incredible career in the bankruptcy field. He was the rules reporter for the rules, and just a wonderful person. Everybody loved him. And to tie in with a later story I'll tell you, he was a Sterling professor at Yale with the gentleman that headed up the SEC reorganization department, and we'll have an interesting comment from me about that later on, because we eventually took the SEC out of the process. At least that was our recommendation, and Congress agreed with that. In any event, I went over to Alisal primarily to meet Harold Marsh and Frank Kennedy and C. Verne, who I knew already at that point. And so we had nice conversations, and as a result, they did recommend that I become a deputy director. So in 1970, we rented our house in Phoenix and had 2 young kids and moved to Foxhall Village in Washington, D.C., and I started working on it. And again, a digression to a degree, but Bart Porter, Newman's brother, was with CREEP, the Committee for the Re-Election of the President. And Bart Porter was having supper.
Richard Milhouse Nixon.
I wouldn't dignify him with the middle name. Any event, Bart was at our table the first night we were there and could have him over. He lived not far away near the Russian embassy then. It was in a different location. And we started talking a little bit about what had happened with the Committee for the Re-Election, and he mentioned that he was going to be interviewed the next day by the FBI. I said, Bart, do you have an attorney? He said, oh, there are all kinds of attorneys at the committee. And I said, Bart, your brother Newman is one of the best attorneys I know. Haven't you even talked to him about it? No. Well, he got in trouble. He went in and gave a little cover-up on an issue and check, and but that's another story.
Let me set the stage for you a little bit.
In any event, I'm there. I'm finished with the background.
I want to talk about the judges.
Well, I think we ought to talk briefly about the 78 Code, its enactment, and Jerry's role in it. And I didn't appreciate really what the forerunners on the the bench had done for people like me and my current colleagues. But before the 78 code was enacted, there were only bankruptcy referees. You couldn't be called judges. Sometimes you couldn't have a robot. You didn't have a law clerk. You didn't have a secretary. Sometimes you didn't have a courtroom. You talked to some of these people and they held court out of the hallways because that's the only place they had. And if you, I don't know if any of you were old enough, if you practiced under the Bankruptcy Act that was in existence before 78, one of the first battles you fought was over whether this was governed by summary or plenary jurisdiction. And there was very limited power that the referee had under the Bankruptcy Act to enter various kinds of orders that we all now take for granted. Well, as the commission got started, a couple of things they did, proposed out of the box, was to give the bankruptcy court total jurisdiction over all proceedings, the magic words arising in or related to the bankruptcy process. That's proposed. And so that the courts could hear those and decide those to make the bankruptcy judges Article III judges, just like most federal judges. Well, that started in about 1970, and it didn't go well out of the box because, and to give you a little taste of history, at that point, there was no bankruptcy referee on any national federal judicial committee. And you don't know this until you go on the bench.
They couldn't even go to the conference.
Well, yeah, I mean, the Ninth Circuit was the first one to invite bankruptcy referees to their annual conferences. Chief Justice Warren Burger, who Taylor Ashworth was a law clerk for, by the way, would not respond to letters written by the referees about the legislation, would not return their phone calls. He would have his secretary or the administrative office do that because he didn't think he should have to deign to stoop that low. So that was kind of the lay of the land as it started. And there were really kind of two tracks. There was a bill proposed that had a lot of that in it, but it also said that bankruptcy would be an administrative process, and there would be administrators. It wasn't going to be a courtroom, there weren't going to be judges, etc. And the referees got involved and created a companion bill that I talked about to make it a bankruptcy court with Article III bankruptcy judges. And as I started working on this, Jerry gives me his written statement to Congress, which I think is in the materials. And there's also his testimony in 1975 to Congress about all of this. And Jerry was really one of the point people at the fight throughout the 1970s that culminated in the enactment of the 78 Code. So Jerry, give us some overview of your thoughts, how that went, and whatever you want to say about it.
Well, as I said, I had a chance to deeply immerse myself in bankruptcy history and background and the existing laws. So I'm beginning to start writing then on various sections. I wrote the community property initial draft. I wrote the fraudulent transfer provisions. I wrote the preference provisions. And the goal was always on my part to try and simplify things and make them clear and understandable. Sometimes it worked out that way, sometimes it didn't. In the meantime, I had recommended to the commission through Frank Kennedy, and I've never told this story. Frank Kennedy was a good friend of Norm Nachman's. There was a small boutique firm in Chicago, did a lot of major bankruptcy work, Nachman, Nadler, and somebody. And Jerry Munitz was a young lawyer there. Jerry's now even older than I am in Lowell. I think he's older than you are, Lowell. But he's still...
I thought we were contemporaries.
He's in Chicago, but Frank, because of his relationship with Norm, wanted Jerry Munitz. But I'd had some matters over in California in the meantime with the Stutman, Treaster, and Glad. It was actually Quittner, Stutman, Treaster, and Glad, and Barney Shapiro's firm, and I felt there was a lot of talent over there, and I'd encountered a gentleman named Ron Trost. And Ron I was particularly fond of, And I suggested Ron Trost get involved with the reorganization part of it and work with Larry King to take what King was working on for the Rules Committee and on his own and integrate it into the approach we were taking at the commission. And Ron did fulfill that part of it. I later then took what they had done and put it into the final product for the commission. But most of that was done by Larry King with Ron's help, and Ron was very helpful. And then I did the final, putting it into the final framework of what we were doing, so it didn't look like something completely separate and different than our drafting style. But I didn't have a major role in that chapter. Well, I'm getting ahead of myself a little. What happened then is I felt strongly that bankruptcy was an important aspect of the American economy and also of litigation in the federal courts. Had to be really a federal bankruptcy law. We toyed with the idea of maybe delegating the consumer stuff to the states, but in the long run, it really needs to be federal. It needs to be uniform. You have to have a uniform law to make things work properly. It would be a disaster if you didn't. But we needed to have good judges, and we needed to be able to attract good people to be judges. So the commission was really persuaded to that, as I said earlier, and they were they ultimately decided they couldn't face up to the Article 3 issue. They couldn't do that, but they could at least recommend that they be appointed by the president with the advice of the Senate, and that there be long terms. I think the term we had in the proposed act was somewhere between 12 and 15 years, may have been 15 years. But again, we did not face up to the ultimate question of Article 3 versus Article 1. And to have Article 3 judge, you have to have life tenure during good behavior. That was really the only significant difference in what we did. And we had fairly elaborate retirement system built in. We had, I think, a pretty good, strong court, except for the life tenure. That was the only thing the commission could not face up to. And Weinfeld was dramatically opposed to that. He was the Article 3 judge that had a great reputation in the federal system from the Southern District of New York. So yes, I think we were strong advocates for a strong court.
Well, apparently not strong enough because I'm an Article 1 judge. You know, the vehemence of those times is just amazing when you go back in history. I assume we all know that we had this 3 branches of government and separation of powers. One of the first things I was informed after I got sworn in is that, you know, you can't be involved in any kind of political activity. Even if I support a candidate, I cannot write a check and donate to that candidate's campaign. Okay, you know, I can live with that. That's a fair trade-off to being a judge. Well, when you go back to the history about the fight for whether the new bankruptcy code or bankruptcy judges were going to be Article 3 judges, constitutional life tenure, fixed salary, one of the main opponents to that was Chief Justice Warren Burger. And he was literally over there in Congress, this went on for several years, actively lobbying that he didn't want these incompetents made into Article 3 judges. It just wasn't right. I've cited to you in the outline the articles by bankruptcy judge Geraldine Munn, which is a really great history of it. But at one point in, I think 1977, right before the bills passed, Chief Justice Burger, as the Chief Justice, writes to the congressional committees and says making bankruptcy referees Article 3 judges is, quote, almost like promoting all the sergeants in the armies to captain. That's how he saw it. Now, at some point it gets kind of humorous because one of the people in the House wrote back to him and said, Chief Justice, you are a really effective advocate on this point, and I'm really impressed with your performance. However, it does occur to me that as Chief Justice, perhaps it might be somewhat inappropriate for you to be over here lobbying all this, because it's possible that someday some of this may come before you in your capacity as Chief Justice of the Supreme Court. So I think what you ought to do, given your tremendous talents over here, is resign as Chief Justice, run for office, get elected to the House, and then you can do all the lobbying and campaigning you want from this point. Well, how prophetic that letter was, because in 1982 or 3, the Marathon decision came out and said the broad jurisdiction given to the bankruptcy court can't pass muster because you don't have Article 3 judges and they can't hear a lot of these issues. And, lo and behold, it's really amazing how things never change, because just over a year ago, the Supreme Court comes out in Stern versus Marshall, and when you step back from all the nits and nats of it, I consider it Marathon 2 saying Article 1 judges can't decide certain kinds of cases, notwithstanding what Congress did in enacting the code. They don't have the judicial power granted under the Constitution, and so you still have this battle ongoing about what to do with the jurisdiction of the bankruptcy court, what to do with bankruptcy judges. And just to begin to bring it back into context, about 2 weeks ago, the president of the National Conference of Bankruptcy Judges was asked to testify, and did testify to the House, about the effect of Stern and the effect it's had on the system, and thoughts about what to do about it, and basically said, you've got 4 options. The last one is to make bankruptcy judges Article 3 judges, and then therefore they can exercise the full grant of jurisdictional power held by the federal courts. So here we are, 30 years later, right back where we started. And just to complete that thought, Skip?
Doing immigration work within a week.
Well,
Maybe you want to repeat, maybe everybody didn't hear it.
Skip made a great point. He said you'd be doing immigration work within a week. I'll tell you candidly, I've been on the board of the National Conference of Bankruptcy Judges twice. There's been a lot of discussion about this over the years. One of the concerns I have is I love being a bankruptcy judge. I love what I do. But I fear if we were to be made Article 3 judges, we would be doing immigration cases, criminal cases, and a whole lot of other things that, to be blunt, I'm probably not qualified to do. I really don't want to. I would take this job to do those things.
Don.
Two comments about this. I originally law school was going back.
In here.
Speak up a little bit.
Pardon?
Speak up a little bit. Stand up.
I went to law school during the Act, so I tail end of that era. But two factors I would throw out. I mean, first of all, quote Nick Scheinfeld was the first bankruptcy lawyer I ever met when I was in law school. There were bankers and referees in that time, or the result of the political patronage system that was done to a person. And there were referees who didn't know there was a rule that was in existence. And quite frankly, didn't help. And everyone knew that it was not. And the fear of those people being raised to the bench was a real fear. It was not a suggestion of a transition. And it was a big fear of people being raised to the level. The second problem was some real deep prejudice. As Judge Montgomery once said, when he started practicing law, if you were Jewish, Irish, or Italian in a major city, you couldn't practice bankruptcy law. You have deep prejudice in the system. And I think it's being very wrong to tell them that I can't. Because that's not there. But attitudes towards law firms and judges who didn't want people from certain minority groups to the bench. It still existed in 70s and 80s, but I think it's kind of used. It's deep.
I know one of the points that Chief Justice Gregory was arguing was it's not just can we have quality bankruptcy
But that wasn't the issue, really. The commission didn't even recommend that, and that's what the judges got upset about. We weren't going to fold them in. We didn't recommend that, and so the judges came up with their own bill that did that.
But the idea of having all of the one person was also one of the little obstacles to making any progress. But I think you pretty well focused on it. By the time it was in front of Congress, everybody knew it had a constitutional issue present, but there was no one, there was not a really organized group out there saying, by God, we've got to make these people Article 3 judges, and they don't have any BS going.
Well, as I recall, in '75, the House's version of the commission's bill did have Article 3 status.
It came out.
But it was
Senate
taken
bill
out.
And the House bill, I think the Senate bill wasn't Article 3. The House bill was, and it goes to conference committee. And if I remember correctly, the conference committee sat on the bill for a long time, didn't meet. And then very late in the session, and somewhat, at least according to what I've read, a little bit, for lack of a better term, somewhat under concealment, came out with a recommendation of resolving the split by not making the bankruptcy judges Article 3 judges. And again, that was really pushed by Chief Justice Berger and particularly the other district judges. There is, I believe Judge Weinfeld, who Jerry mentioned, was the chair of the National Bankruptcy Committee, and they were also lobbying to get the Article 3 part out of there and make them Article 1 judges. And the bill actually then kind of sat, and it was getting very late in the session, and there was a big push at the last minute. I think that was one of the last bills that President Carter signed.
He signed it on my birthday, November 6,
Do you want to talk about
1978.
Arizona judges?
All right, so I think we've kind of given you a taste of where we all were in terms of the history that got us to the code. So we get the code in 1978. And I think we ought to shift our focus now and talk about Arizona. And I think we have to.
Let me just clean up one little point, the SEC. The SEC was active. They had their protective committee study starting in the 1933 or 34. Douglas headed it up. It was 8 volumes. The final volume is a masterpiece. He wrote it. And we didn't used to have reorganizations in the Bankruptcy Act. Instead, you would have a receivership, either federal, and it was primarily federal in the major matters, or state. And there would then be a committee formed, and Cravath, Swain, and Moore was one of the leading advocates of that approach because Swain was one of the persons who made an incredible living off of these protective committees. And so he was adamantly against the SEC coming in and getting involved or creating a reorganization statute. So in any event, in 33, they passed Section 77, which was really the forerunner of Chapter Roman 11, which became merged in our Chapter 11 of today. And it was for smaller cases. The SEC wasn't involved. But then the next year, the SEC had 77B, which was for reorganizations. The petition had to be approved by the federal district judge when you filed it. And it was ex parte, but still he had to look it over and decide whether or not to approve it. That then initiated a process where the SEC was intimately involved from the very beginning in the entire process. One of the things we did was, and I had told you Frank Kennedy's great friend was at the commission. We used to have Wednesday lunches with him and his staff in Washington, D.C., near, I think we were on 16th Street and K, near there, 1611 or 16, I forget one. In any event, we'd have lunch with them and we'd talk over things, and it was pretty close. Well, when the commission decided to eliminate the SEC's role Frank had to go back and tell his friend that we've just eliminated, disemployed you. And I heard that conversation. Frank had invited me into his room to listen to it, and it was incredible. The guy was so unhappy, and pretty rough conversation. In any event, they then worked hard to stay involved. But that was the way the SEC was taken out.
Let's shift to Arizona. Lowell, tell me, if you will, kind of, you got the section formed in 1955. I'm just curious, what did you guys do?
We gave educational programs. It's interesting. There's a list in here, and I thought it was, I was laughing at myself because I spoke on how you prepare schedules, which nobody thought was very interesting, of course. But I've also always taken a lot of care
Gotten pretty complicated.
on schedules so that something didn't come and bite me later. Of course, later on, the 205 code, I guess it was, caused the lawyers to have to, I don't know, are the lawyers here to do consumer work? Had to verify the truth of those Chapter 7 schedules. I have not signed one in the last many years. It isn't that I'm a cynic about what my clients tell me, but I didn't want to have any continuing liability or exposure. One of the things that was interesting about this, there's a list of referees starting in 12, and I mentioned it, and I got this from the clerk of the court. I didn't even know they existed. They were appointed, of course, by the chief judge, but the interesting ones were Tombstone, Globe, Morenci, and what those were there were the mines were closed down. These are contemporaneously with mine closing down or strikes, and they would have these bankruptcies, and they didn't come to Tucson or Phoenix. They had the bankruptcy court in where the incident occurred. And then Alan Perry. Did you know Alan Perry?
I knew Alan Perry.
Yeah. And I didn't know he had been a referee. And in the program, there's a list of this program which the new bar group did later on in '66. Henderson Stockton is giving a speech. I didn't know he had been a referee. He never let on. And then, of course, Stanley German, who I've talked about. But Caldwell, Crackiola, Majori, and Davis really were referees until anointed by the '78 Act. And then you will see this repeats now. Caldwell, Majori, Davis are all of a sudden judges by virtue of Congress.
This must have been Joe Jenks' father?
Yes, that's who it was. I was trying a case in front of Moorman, and very busy objecting. And it was interesting, the lawyer on the other side was Neil Wake, who I now obviously must know more about evidence. He couldn't get anything he couldn't lay a foundation to get this in evidence, and I was being very smart and obnoxious and objecting. And
You?
And
Now you've been to every ruling.
and Moorman took a recess. He went off the record and he said, Lowell, and he didn't call me Mr. Rothschild. He said, Lowell, do you not think I understand the difference between relevant things and irrelevant things? We'll be here all day long. I'm going to leave the bench. You're going to show Mr. Wake how to lay the foundation, and we're going on. And that was fine because he ruled in my favor. I didn't care what he said. Then there was,
Question.
the,
More comment. My first appearance in the court of Arizona was before Vincent Ferrari recovered. I stood up and tried to make some sort of an objection. And he said, shut up and sit down.
Can you speak up a little?
the man said he appeared in front of Judge Majori and started to make an objection, and Judge Majori said, "Sit down, shut up and sit down." My reaction to you is he was a little short in temper.
I think that's being generous.
My reaction was that was plenty of power. I didn't think he needed it.
Well, let me tell you my relationship to him, and because this is when it's being videoed. Apparently, he had a lot of stomach problems, and somebody told him one day that if he rolled a bowling ball on his stomach, he would get rid of whatever it was, gas or whatever his problem was. So I get a call from his clerk. And his clerk says, "Do you have an extra bowling ball? We know you're involved with bowling." And I said, "Why?" "Well, Judge Majori's coming to Tucson, and he'd like to pick it up." And I said,
No wonder I always lost when I had you on the other side.
and I said, "Okay." My phrase for that is, it was a little informal, is the best I could tell you. And then Ed Davis, and then they all became by Mr. Smith's hard work judges.
Pre-code, if you needed to find a bankruptcy trustee, and it was 2 o'clock in the afternoon, go to Grant.
You could get orders signed in Durant by a lot of judges in the afternoon.
And so then there was William Scanlon, and he was at Bill B. Schoenherr for a long practice, and apparently did a lot of employment work, a lot of things, but had grown to not care for government very much. So when the NLRB showed up, they didn't do very well. I told you about the yellow cab case that got reversed, and the good job that at that time, I think Don was at Strike-Lang, and Bill was pretty even-handed. He had seen a lot of things, had a personal tragedy in his life, and which a bunch of us had to participate in. And the thing I found interesting, except for Joe Cracchiola, as we come into the modern, what I call the modern age, Nielsen, Allison, they all had long terms. So that we had, they sat on the bench. George Nielsen will now be on the bench 28 years, in 1983. So there is a certain stability to who you're practicing in front of. And I'm going to recommend you, and we'll talk about it later, Judge Marler, or Jim Marler, wrote a paper on the Baschik case, on getting confirmed the Baschik case, which I suggested to Rob Charles, who was teaching a course at law school. You ought to take that and hand it to all of your students, because it's a great outline. Skip.
I used to teach bankruptcy at Peter College for 20 years.
And Mary Ellen was,
Rob came every year to do a lecture on preparing your lawyer for a confirmation hearing, and he developed that out from 6 or 7 pages to 25 pages, and I gave it to him.
I always gave Marler original credit. Don't tell me that. At any rate, but in it he said something, and I can now say this, as Smith enjoyed telling me, well, you're really kind of the oldest and maybe the youngest acting. You know, it's a typical Smith response. He holds you up and then he makes sure you realize things. Marler, in that paper, wrote something that I thought was not an admission, but something we can all learn, and there are a lot of experienced people in there. And I thought it was fascinating, particularly as we have a judge going out and a judge coming in, we think, sitting here. And he wrote a line, know your judge before you start. And I thought that the good practitioners, the successful practitioners, and by that my standard is if they get their cases confirmed, and if they're doing the best for their clients, really have to understand. Maybe this is the word, the what motivates that judge about him, and watch what transpires. But it was interesting that Jim recognized that maybe about himself and put it in. I thought it was pretty good advice. So then we came.
Let me chime in on that point with a little story for you, following up on the comment about Judge Majori and his demeanor. At some point it dawned on me as a bankruptcy lawyer, the one place Judge Majori didn't want to be was on the bench in the courtroom, listening to lawyers put on evidence or argue. The key was to get back in his chambers, and he had these big, very comfortable, massive leather chairs, a little bit lower than his bench, so you had to look at them a little bit. Was to get everybody back in there, and then try and get him to turn on opposing counsel for some reason and start arguing your case with opposing counsel. And if you got that far, you were going to win your case. Conversely, if he was arguing with you, you're going to have to figure some way to try and get that spotlight shifted back over to the other guy. I think, I personally like Judge Majori, but I have to say, I think temperament-wise, maybe the worst temperament of anybody I ever ran into on the bench to be a judge. Just was not a patient man and would very quickly turn on somebody. So the old adage, know your judge, is really critical.
So then we came, then still at the point of Nielsen, Ollison, and then we came in Sarah Curley. So I'm going to tell a story on myself. I was chair of the, and I wasn't chair, my partner, who was a federal judge, Alfred Marcus, was chair of the committee when she was selected. And on it was Paul Bender, and then a partner of yours who I don't
Ralph
remember.
Mahol.
Yeah, I don't remember. And it was interesting, so you know, we had, what's Kahn's first name? Jim Kahn filed his application late, or he would have been the judge. And we had Barbara Caldwell, and we had Sarah and Don Zeitlin. So Don Zeitlin, and we had we saw 8 people out of 640 that we interviewed on a Saturday. And I love to tell this story. Dawn Zeitlin was probably she was very qualified. She was extremely qualified, but she was like 32 years old. And here we're sitting with all these old men. And she walked in, and she was a convert. She had married my fraternity brother's son, and she's a good lawyer. And she was being married on Sunday. And our interviews were on Saturday.
And she was converting.
And she had converted, and they're the worst. Anyhow, and she was very dedicated. So she walks in, and she's sitting with this Hispanic judge and these 2 Jews, Paul Bender and I, and she says, "You're nothing but a bunch of prejudiced people."
So how's the interview go?
Not very well. And she said, "Why did you set this on Saturday? I should be in synagogue. I'm being married tomorrow." Marcus said, when we recessed, Marcus said, "You think she has the temperament to be a judge?" And that was the end. Lovely lady. A very smart, bright gal, but her one sentence doomed her, so now she's off picking oranges and being very rich with her husband.
Apparently not quite as smart as we all thought she was.
To follow up on this bit of levity, I wanted to tell the story about when I first got involved in a bankruptcy case. It was Consumers Mart of America, and I think it was 1962, and I didn't even know how to spell bankruptcy.
It's only 50 years ago.
And McGarry was working with Stutman Treaster, Quittner, Stutman Treaster and Glad, and this was one of the first chain stores that had ever been developed. It was from Florida across to California. They had a place in Phoenix, and they got into financial difficulty. George Raft, who was in England at that time living there, used to open up their stores for them, and they'd have a big spread. In any event, McGarry filed a 77, which is the equivalent of later Roman 11, for small corporations. And it didn't have to be approved by the judge. But McGarry got it approved by the judge. The federal district judge approved the petition. And I got to reading things a little bit, and I said to McGarry, "I've been looking at these leases. We're going to have some problems coming up." And I looked back at the order approving the petition, and the leases all had a default clause that allowed them to be terminated if there was a petition approved by the federal court. Apparently, the person who had drafted the leases hadn't really focused on the difference between the two reorganization cases, and McGarry certainly hadn't. And from that came my tendency to always tell the younger person, read the statute. I told McGarry, you better get that eliminated, so he went in and got an ex parte elimination of the order, and no one ever raised the issue.
So then we came to the selection of judges by the commissions. And there was Curley, Baum, and if you look at it, like Sarah was appointed in 86, Baum, who's quitting us, running off, is 90. That's now 21 some odd years, 22 years. Jim and Case, and then we're left with the two. So the real point of this is here practitioners are there, and I look at the lawyers who are interested in all that, and they understand the rule. And now there's going to be an entirely different cast. And so I guess my advice is be patient. I think the level of selection, I think the method is better than it was. I don't think you can ever come to watching it for all of these years. I don't think you can ever really come to a perfect system in anything. Everybody does their best, and you see, because as you talk about, we've talked about 10, 12 that you all know, most of you all know, starting with Hugh Caldwell. The kind of the wild card was Joe Crackiola. That was kind of a strange little transaction. That was really, again, a relation. I'll call it a relationship appointment
With Dennis,
with Dennis. Yeah, that the whole family was.
he became a pretty good judge, though.
He was all right.
Yeah, I think Skip Woods clerked for Hugh Caldwell.
No, I clerked for Scanlon.
Okay.
And Michael's. Michael clerked for Mickey and Caldwell, but he had long hair then. As my wife said, you hired him 20 years later.
Well, when you think back about some of these judges, when you tried a case in front of Hugh Caldwell, he would lean way back in that chair and he would close his eyes, and if you didn't know better or you hadn't been there before, you would think he was asleep. But that's how he tried cases. He was not asleep. And woe to any attorney who intimated that perhaps he wasn't paying attention, because at that point your case pretty much was over the waterfall.
I love my Hugh Caldwell story. First of all, I learned more from him than I could ever learn from anybody. But I would go to Yuma, and I had a case. I went there 52 times. There was a farmer who,
On the same case?
on the same case, and 52 times. And,
What'd you charge?
well, let me tell you, after 52 times, and I was representing a trustee, 52 times, this is a farmer who either intentionally drove into a canal or accidentally drove in a canal and left a $4 million policy. And Hugh Caldwell, at some point in the proceeding, decided that $2 million of it was exempt to the wife. Don't ask me the law. I could not tell you what law that was. And, but there was enough
It's
left.
Arizona statute.
What?
Arizona statute makes it exempt.
Right. At any rate, so I had my feet come up. We didn't get interims at that time.
Unless I made a mistake in the Coles
No,
case,
you
they had
didn't.
45 million.
Yeah, I saw that. So you came, you made your application, but it was basically at the end of the case. And it was in the juvenile court, and Tom says he sat there in juvenile court, and Hugh, after every matter at that point in his life, would take a recess and go in his chambers and smoke. So my matter came up, and it was the fertilizer company that was, and this was a very important thing to my life, this $75,000 fee. And Mike Smith was the lawyer. And we recessed, and then we came back together again, and there was no Mike Smith. He had walked into the detention part, walked out to the right, which is a padded cell. And they, fortunately, it was a Friday. We'd go there on Fridays. And they brought some truants in that week, and they retrieved him at like 4 o'clock in the afternoon. So the moral of the story is don't ever object to my fees.
Now, in the old days in Yuma, you either had to take a very rough flight on a small plane or drive almost 3 hours one way from Phoenix to get there. Either Judge Ollis or Caldwell held court in the state juvenile court, and there were only 4 chairs for lawyers in that courtroom. In those days, it was Jimmy D. Smith, Mike Smith, Ted Bowen, and John Wheel. And I used to do a fair amount of work down there, and at some point I realized the way to get them to get out of your case quickly was to get there before one of them, get one of those chairs, and then they were so anxious to get into that chair, they really wouldn't want to fight or argue that much about your case, and you could get heard early and get out of there and be on your way without a great deal of problems.
They now have a courthouse named after John Roll.
Who was a wonderful human being. I forgot my
Speak
hearing
up.
aids.
Did you think enough credit was ever given to Judge Morgan for saving our hometown area?
That I didn't participate to any degree in that case, but it certainly seemed to me that it went very well. And I don't know.
Don, you go first.
Well, I agree with that. I think it's critical. There was a practitioner in Dallas who was pretty pull his hair out there several times. And Judge Moore basically not even here while you're here. It's an absolutely critical here. The other thing which a lot of people don't know was that airline ran out of money. And it reached the point that they knew exactly the day they could not buy gas any longer. The banks would not extend. And there was a group of business people who, in Phoenix, who pulled up the cash because the banks said, the money banks said, we will not extend the deal. You have to have X amount of money put into the state. And there was a fairly infamous meeting that occurred among some banks. The banks told people in Arizona.
I heard that then Governor Symington was kind of leading the herd of the businessmen to get them together, saying, I remember the number, I want to say it was $10 million, but whatever the number was, he was basically saying to them, they'll be gone if we don't have this money in their hands by this date. And we'll start to go around the room and say, okay, Sheehan, I need this amount from you, Cross, this amount from you, and that's where it came
I
from.
was a lawyer in the room. But the greatest moment at the meeting was Bank of America was the first bank to take over out of state during that transition to over the National Bank. So they had a new crew that was sent down from San Francisco to Bank of America. When they got to Bank of America, it was almost an infinite group. Barry Douglas, Sons, and Valley. Such Bob Logan was number 2 in Valley was there. And for those of you who remember Bob Logan, pretty tough to read. Campaign's way up and some money. And they got the Bank of America guys, they said, well, we might be willing to do this. We're going to have to do so-and-so kind of background, we're going to do this, and stars are going to have to align with Mercury for us to do this loan. And Logan looked across the table and said, I'm going to make the loan today, and I'm going to write it off tonight. That's how much I think it's collected. And you ought to make a decision now, get out of the room.
It's interesting when you talk about, Brenda, did you represent a secured creditor in that? I didn't hear much.
Unsecured creditors committee.
I find, we're going to talk about the various industries you can see from the outline, but how about the wheel turning that now U.S. Airways is talking about a merger of American? I find that the American story. It's a capitalist system.
Well, if you look at the outline somewhere on their Chapter 11 mega cases, number 2, the airline industry. And almost every airline in the United States has been through Chapter 11 at least once. So here we go again. Now, I got to tell you a couple of war stories about America West. I believe it was filed in 1991, and I've just gone on the bench, and at that time, Bob Mormon, who draws the case, is the chief judge on the BAP on the road a lot. And so he asked me, could you hear the first day hearings, and they need a DIP loan approved? Sure, I can do that. So I heard it, no problem, not a lot of fight about it, approved. Well, a couple months later, he says, you know, they're coming up on the second loan hearing. I've got to be out of town. Can you hear it? And I said, Bob, I do it, but I'm gone. And, you know, if you knew Bob well, he kind of sighed. And I said, you know, I think Mo could hear it. And he says, do you think there'd be a problem? And I said, I don't think so. I think it'll be fine. So I was up in, the hearing I believe was on Friday. I'm in Pine Top with my family on vacation, and they're all sleeping in, so I get the morning paper, and I open it up, and I get to the business section, and there's a headline and a story about the hearing. And this is the one where Mo asked one of the lawyers, do you know the meaning of retromension? No. Go get the dictionary and find out. And then when they got to the fee applications, he said to the lawyers, he said, you know, I was thinking, I flew up this morning on America West, and the flight attendants told me that they have been, for years, paid an America West stock, which is now worthless. And so I think in fairness to the system, we ought to pay all of you professionals with America West stock. Well, I mean, all the orders got in, everything got approved, and it was fine. And Mo never heard anything else in that case. But he did, I think at the confirmation hearing or one of the hearings, unbeknownst to Bob Mormon, Mo sneaks out on the bench before the hearing starts, and all the lawyers are just over there. And he walks over to the bench, he says, looks up and says, I just needed to get a pencil, excuse me.
You know, you can tell 1,000 Mo stories.
Yes, you
But
could.
one of them that you reminded me of, somebody would show up, and I was telling them last night, and I had filed multiple 5 or 6 cases, of, what we call the Kerry Marmus cases, and which Michael finished up properly at the end. And somebody came in, and he starts out with this lawyer from Dallas, and he says to him, did you get that suit you're wearing on sale at Brooks Brothers? And that totally collapsed the guy. He didn't know what to respond to. And then another lawyer was there from Strike Lighting before it was Coils and Brady, and he had an area in his ear. And Mo says to him, does Mr. Strike know you wear an ear in your ear? And the kid turned white. Absolutely white. He said, don't worry, I won't tell him. You don't have other conversations with him. He just, but then I was reminded last night by the judge of the sign he had in his podium that sometimes said, I don't know exactly the first thing, but it referred to Mr. McGrath speaking in the courtroom. A physical sign he had. And then when he wasn't there and I was there, it was Mr. Rothschild speaking in the microphone. And he had these signs that he would have put, knowing that we were coming there. It did kind of quiet us down a little bit.
Excuse me?
Then I'm going to tell my last story on myself.
Clock installed, and he would say, good to see you, start the clock. And if you thought you had gone too far, you just stop and say, how much time has elapsed since you moved on?
And I've never quite understood this, where he would order you to...
The Salerno seance room?
Yeah.
You don't know that story?
No. I know the story, and I've been ordered into the Salerno room more than once. I never know how Tom got the name, the permanent name.
I don't know the specifics, but I know this is going to shock everybody, but I think Tom was being a little obstreperous. And the out to the room, I believe, got started when Mo told Tommy J. Salerno and whoever else was involved in the case, out into the room and talk it out and work it out and stay in that Salerno seance room until you do. Don't come back here until you have it worked out. I have, we could spend a lot of time telling Mo stories, but I have to share this one with you. Mo had been the judge in Tucson, I think, for about a decade when I went on the bench in 1990. And the way the assignments were going to work is I was going to take over a third of the cases in Tucson. So I would be the first bankruptcy judge in Tucson in over 10 years other than Mo. And if you ever appeared or practiced in front of Mo, he had a different style about running things. So right about the time I get sworn in, Mo calls and says, can you come down and have lunch, and we'll talk about how to reassign the cases. In those days, there were no computers, so you had to manually say which cases were going to go, which cases were going to stay. As a little aside, because Mo was the only judge in Tucson, and he was, in my opinion, a very pro-debtor judge, if you had a debtor case in Arizona and you could figure out a way to file it in Tucson, you did. And so there were some cases on that list that I couldn't take. He says, if you would, be in my chambers no later than 11:20. Fine. So if you remember the old La Placida Village, he had that kind of second floor place. So I get back there and I can't find Mo, and I'm talking with Blanca, and I said, do you know where Mo is? And she said, come on, I think he's in the chambers. So we go into the chambers, and there's no Mo, and she says, oh, there's an emergency hearing that I think you're going to have to go here because Mo's not here, and kind of slips the robes on me and opens the door and shoves me out. And I look out there, and here's the court staff, and there's probably 10 lawyers in the courtroom, and they call the first case, and you're just standing there going, you got to be kidding me. I have no idea what's going on. It was a total setup because in about 30 seconds, Mo comes in and sits in the back of the courtroom and watches me fumbling around. Mo was a great friend of mine. I think it was about 10 years that he was on the bench that I was a lawyer. And I think every time I was in front of him, it was representing some bank or financial institution. And I don't know the number of cases, but I'm fairly confident that whatever the number was, I was 0 for something in front of Mo. But he was a dear friend.
I bet I was never on the other side.
Oh, unfortunately. Do you remember the first time I met Mo? I take over a case from Billaby Schoenherr from Valley Bank. It's kind of a mess. So there's a hearing in the afternoon in Tucson in the old Walsh building, at the bottom there where Caldwell used to sit. So the bankers and I go over and we sit down in the courtroom. It's about 10 minutes before the thing. And it's now, 1:35 and it's supposed to be a 1:30 hearing. So I kind of walked back and said to his secretary, I said, introduced myself. I said, is there going to be a hearing? And she goes, oh, I think you're supposed to be in chambers with him. So I go in there and there's Judge Caldwell and Lowell Rothschild. And at this time I did not know Mo. And there's a guy with his feet up on Judge Caldwell's desk and his hand behind his head. And if you ever walked into a room and killed the conversation, that's what happened to me. And that's the first time I ran into Mo and one of the early contacts with Lowell. And things didn't go well for the bank in that case, is my clear memory.
Are they still in existence, the bank?
I'm sorry?
Is the bank still in existence?
Valley Bank?
It became Bank One, and now it's J.P. Morgan Chase Bank.
Skip.
I was Scanlon's clerk. And Allison and Scanlon were good friends, as Lowell was with them. And I had been at legal aid in days when there was still Article 3 kind of stuff, and you had to file a complaint for relief from stay instead of a motion. When I had been at legal aid, we used to do counterclaims. You could sue for both out. I got all this fair debt collection, I'll do that. So I taught that to Mo when I was Scanlon's law. And I remember Scanlon came into my office one day with this pleading, and he threw it on my desk and said, it's from Mo, fix it.
Yeah, pretty powerful.
Don?
I know it's deep in the worst part. Mo Allison's largest case, he managed to solve at the first hearing. The largest case he ever had was the Tucson Electric. And I represent one of the petitioners that involved Rick Bath represented IBM involved in that issue. And Rich Levin was at SCAD in LA at the time, representing Tucson Electric. We filed it voluntary. Initially filed the fee was just no one wanted it. And Judge Allison called it.
How long did it stay in Phoenix, Don?
I think all of it out. For all of it.
Is he talking about TEP?
Yes.
Well, and that you brought it up, I'll bring it up. So Don files this case in Phoenix, which pissed Mo off. And it comes back to Tucson. I don't know if any of you realize, there was never an order entered into that case. He never adjudicated.
No, you know why?
At any rate,
Let me tell a story. This is a good story. We have the initial hearing. Rich Levitt, who we've ever worked with, is a great, one of the best. And Rich gave about an hour and a half presentation about the electrical industry in Tucson Electric, that structure, and the issues. It was brilliant. And he finished doing his presentation, said, "Thank you, Judge, for the time," and got a whole series of issues, and said, Mo looked at it, picked up some papers, kind of did like this, and said, "I'm appointing
Tom Chan.
special examiner as to whether or not the rates should be lowered for electricity in the city of Tucson," and stood up and walked off the bench. We went out to the corridor, and the lawyer from Quebec and the guys from Stan said, "There is, I'll leave out all the extras. There is no way this case is going to go another minute from this judge." The case was settled, it was never really heard.
Yeah. That was an interesting case.
That's a good case.
Also, what the line that Don doesn't tell him, so it's classic, is he's there and he's up arguing, and Allison says to him, "You know, when you shoot the king, you better be sure he's dead." That sent the whole message.
How long was that involuntary detention without a word from Lee?
And that was pretty important. It was pretty important to our community.
No, we did not have it.
It didn't make any difference. That was what the case was going to be.
That was not going to be the case.
Should we take a little break? Everybody get coffee?
Why don't we take a 10-minute break, and
Arizona practice.
we'll come back and talk a little bit more about Arizona.
Thanks. I needed that.
Only for you,
You
Tim.
needed to smoke.
I could see you did need a smoke.
Are we doing okay, Coach? You hear me? Are we doing all right?
I think we need to speak up a little bit.
Okay.
Please, I can't hear you.
Okay.
Jerry's got the mic right. I can hear you. I can't.
No, it's me. I will talk right in.
Well, tell me what. My hearing she's already who's the quiet. She raises hell. She's always like saying to me, "Go get it."
Well, I know my hearing's impaired, and I promised my daughter-in-law, who is the kindest, nicest, empathetic person, who finally got the guts. She said, "When are you gonna have your hearing tested?" I said, "I'll promise you by September 1st I'll have my hearing tested."
I told my mom and dad on Thanksgiving, I said, "I'm already dead for Christmas." That's all we do. No, I give it.
Yes.
And they're hearing aids. The two of them. They say, "What?" They looked at me and said, "Really?" They went in before Christmas.
And what happened with your mother-in-law? Anything?
She's moves in and can't make it.
And is she's not happy, but
We were all out to dinner with my mom and dad up in Hacienda 10 days ago. Instead of stop, I've got an announcement to make. I've decided I'm moving out to Henmaker and moving out of my home in Phoenix.
Oh, my.
Thank God. We were all like, whoa, great.
Should we go in again here?
Let's get started.
Just, have a couple of housekeeping matters that may help with the materials. One of the interesting things about putting together this program is I discovered that 3 very different panels had materials that largely overlapped. And so to the point that at certain times as I was looking at the materials, I had to try and discern which group it was. The panel this morning actually mentioned 2 articles or sets of materials that are elsewhere in the materials, so I just wanted to let you know where to find them. The Bashes article by Judge Moorman is at page 363. Judge Marler, there we go, Judge Marler, a later M. By Judge Marler is at page 363, and the litigation panel tomorrow also included Jerry Smith's materials from talking about the Article 3, Article 1, and the need for bankruptcy judges to be Article 3 judges. Those are in the litigation panel's materials at page 137. So if you're looking for those, they're in the materials in just a little different place. I was going to share one other aside from where the panel concluded. It wasn't just Judge Moorman in the 90s that kind of kept the entire Arizona economy afloat, as you know, as it was all of our judges, as the entire real estate economy was crashing. But in some sense, you don't appreciate perhaps how difficult that was until you realize that with America West Airlines, that case was filed a year or 2 after Eastern Airlines was filed on the East Coast. And for those who don't remember, Eastern Airlines did not have a particularly successful conclusion. It stopped flying one day in, as I recall, July of '91. And I don't recall the judge who handled that case, but he was roundly criticized for having let that case go on and all the things that happened in that case. So when Judge Moorman was making the decision to keep our hometown airline afloat, there was some precedent from the East Coast that probably made that a little bit more difficult decision than what we can really appreciate after the fact, years later, when we know how the case came out.
Yeah, that case was filed based on the incorporation status of the frequent flyer company. Harvey Miller filed it in the Southern District of New York, and it seemed to me it was assigned, and I can't remember his name either, but it was the judge that handled kind of the upstate New York cases.
I think that's right.
And
In re Ionosphere, as I recall.
yes,
Yes. You'll never find Eastern Airlines, but if you search for In re Ionosphere, that's the name of the case. With that, I'll turn it back over to our panel. Thank you.
Well, I think we were kind of talking about the bankruptcy judges past. We haven't quite got to the current group.
you know,
I want to talk about them too much.
if I could interject one thing, and I don't know if I can make this available to the state bar. It'd be good to circulate to the bankruptcy committee. It is Harvey Miller's oral interview of Frank Kennedy. Harvey gave it to me, and well, Frank actually sent it to me. I've got a cover note, and it was done, I think, in the early 2000s, before Frank developed Alzheimer's so badly. But Frank Kennedy was absolutely incredible, and I'm just going to make one reference in here. It's his tenure on the Rules Committee, and I hadn't even realized it was so long. It started, I just read that, I thought I had marked it. If I can't find it quickly, I'll... In any event, it was almost 16 or 17 years. It started in '73, and he was the draftsman of really what is the major backbone of our rules today, and did a wonderful job. And the other thing he discusses with Harvey is the need for legislation to allow the rules to override the Bankruptcy Act or Code, as was become known. And he refers to it as the famous Section 2075. And Frank says, this is Harvey's question, Frank had said we were handicapped because in working on the general orders by some archaic language in the provisions of the statute. So we drafted a statute to authorize the Supreme Court to promulgate bankruptcy rules that would become the binding law of the land, even though they conflicted with the Bankruptcy Act enacted by Congress. Then Harvey said, was that the famous section, I'm sure he's referring to 28 U.S.C. section 2075. Frank answers yes. There was a very broad statute enacted by Congress authorizing promulgation by the Supreme Court of bankruptcy rules that would be binding, even though in supersession of a federal statute, and we were very bold. We didn't have any battle in Congress on the bill. Congress passed that law, giving the Supreme Court the authority to write it. But then they raised the question whether that's constitutional. But fortunately, it hasn't been ruled on yet. But that might be an issue that comes up someday as to whether that can be done.
There's a section in your outline. I'm going to talk to the mic so everybody hears me. Apparently, I was mumbling, which I tend to do. On the Arizona bankruptcy practice, we have an outline of, or let me phrase it this way, Judge Baum very well outlined the 60s, the 70s, the 80s, the 90s, and whatever, in the 2000s. That's fine, in that I started practicing 8 years before you start doing it. We did have cases before you were born. I want to talk about a couple that I was involved in, and then we'll talk about some of your questions. Arizona Atomics. Let me tell you about Arizona Atomics, which was a Tucson case. Was owned by, basically by a man by the name of Keith Brown, who was the senator from Santa Cruz County. And American Atomics made exit signs, just like the one that's as you leave here, and they used to light up the exit signs with some kind of chemical called tritium.
And it was in every commercial airplane.
So at any rate, at one time some employee, and they did a lot of glass and used a lot of things. At one point, some employee did something, dropped something, and there was an admission from the locale where Arizona Atomics was. They were next door to the main food processing facility for the Tucson Unified School District. So a number of the parents got very, very upset, went to Governor Babbitt, and Governor Babbitt exercised the police powers by organizing the National Guard and coming down and raiding the American Atomics and closing them up. About that time, Mr. Schoenherr, Bill B. Schoenherr, and they were always late when they referred me a case. There had always been, after all, why would you dirty your hands with bankruptcy or anything like that? Later on, they learned. And so we filed an 11, which, of course, enjoined them. Bill Scanlon was the judge at the time. And with his objectivity towards government, the first thing he did was say to the state, and do any of you remember Tony Chin? He was the Solicitor General for Bruce Babbitt. He came, a very nice guy and a good lawyer. And he came down and they called in Scanlon ordered, where did you get this information that it was hurting people? In the meantime, I had gone to the university and talked to somebody in the chemistry department. He said, oh, you can drink that stuff and you won't, nothing's going to happen to you. But it really caused people a lot of anxiety. So they took all of our equipment, ours, I don't get involved in my cases. They took all of the equipment, packed it up in National Guard trucks, and moved it to Flagstaff. And so the real case was about, and by the way, the lawyer for the owners was the guy sitting to the left of me, Mr. Smith. And he said, go get him. Well, they had a mortgage, to Southern Arizona Bank. So the whole case revolved around how we could sell this stuff and reduce the debt we had. American Atomics was never going to be a viable company again. It was gone. The question is, how do you minimize the loss, basically? About 2 weeks into the case, the people in Flagstaff said, well, if it's not good enough for Tucson, Governor, why is it good in Flagstaff? So here's my thrill. My wife says that sometimes I'm the only person she knows who might have an orgasm over a confirmed plan. That's her kind of private joke. And I said, so now we had to stay. And he was stuck with all of this poison in Flagstaff. So I went to Phoenix, and Tony got me an entry with His Highness the Governor. And it was big play. I mean, he was saving the world with the National Guard coming down. And we negotiated a truce on the basis that he would go away as we sold these things. We had a standard of how it cleaned up, and he got to move, they got to move to an actual real repository for dangerous chemicals. So that was a untold real story, but a real interesting use of a Chapter 11, and it was fun, if that's what turned you on.
Of course, they didn't survive that.
No, they were gone.
And the airlines no longer use tritium. I think it was eliminated everywhere in the United States.
The other case, I'm going to talk about 3 cases. The other case I'm going to talk about is, to illustrate the utilization, was the city of South Tucson, which was filed by Mr. McGrath and I as a Chapter 9. What happened was that the city of South Tucson, which is a square mile city of 98% Hispanic people, had a very complicated history. Part of the street as you go down 6 was occupied by a lot of
Be kind.
enterprising houses of prostitution, a lot of gambling, a lot of issues. But they were working very hard to kind of get it all straightened out. They had a great city manager, a guy by the name of Enrique Serna, and they had a joint agreement with the city of Tucson police that if there was some big exposure of some sort, they would jointly go out. And there was a domestic relations fight, and both went out, and the South Tucson police shot Mr. Garcia in the back, one of their co-officers, and made a quad out of him. That case was tried in the Superior Court, and a $4 million judgment was rendered against the city of South Tucson, for which, during a period where they had lapsed on their insurance policy. So I think they had $100,000, and so we filed a Chapter 9. One of the requirements, and today is a requirement, is you have to negotiate with your major creditor. And that came out of a history of the New York City bond things when they did all of that. I read on the ABI blast the other day, because of Stockton and San Bernardino filing, since 1980, there have been 250 Chapter 9s filed, 20 of which are cities. The rest are waste product situations. The Jefferson County, Alabama one really has to do with a different system, which Ken Klee recently gave a lecture on that Brenda and I were at that was really interesting. And the problem is even getting more complicated down there. So in the city of South Tucson, we filed the 9, and the process had been, or it still is, that the circuit appoints a district court judge and a bankruptcy judge. That's to keep it really being bankruptcy judges that are involved with the cities. And they appointed Richard Bilby, who was the chief judge at the time, and Bob Moorman. Bob Moorman never entered an order in the case. Bilby kept the case. Bilby was going to come to a solution. And so the first day hearing, John Dawson was representing the injured Garcia. And he made a motion to dismiss, we weren't qualified or whatever it was. And I like to tell this about John. He got up, you know, huge that he was, and said, "My name is John J. Dawson. I'm a partner at Strike Lang." And he went on, and Richard Bilby said, "Together with the other 100 partners?" And well, that already set the tone of the case. Bilby was going to be in charge, and it really didn't make a lot of difference what the lawyers were doing. And then he looked at me and he said, "And file a plan in 60 days, and no short stopping. You know, the real plan, Mr. Rothschild, you're not going to negotiate." John also said to him, which I thought was a fatal error, "You can do one of two things, Judge, in a 9, and this is kind of an interesting part of a 9. You can approve the debtor's plan or deny it. You can't do anything else. You either got to go up or down." And Judge listened. I thought to myself, "John, don't talk to Richard Bilby that way. You're going to get in real trouble." So the next thing, we got an order denying our plan. And you, I don't know if you remember, Michael, denying our plan and saying, "But if you amend it, A, B, C, D, E, and F, I will confirm it." So the judge was writing the plan. I mean, he was a very activist judge, to say the least. And he was obviously bound and determined that South Tucson wasn't going away under any circumstances. And we didn't, we couldn't get to a solution, John and I, for economic reasons. It had nothing to do with any of that. And so Bilby called us in and he said, "I'm going to appoint Earl Carroll as the mediator." I said, "Oh." Well, Earl Carroll, I had been the president of a water company that Earl represented very well, by the way. And I was talking to somebody the other day. Earl is he went on the bench the same time as my ex-partner, Marcus. So Earl's 90. And I said, "How's Earl doing?" He said, "Well, he's a little grumpy." And I said, "Really? No kidding." At any rate, we ultimately settled the matter, and we settled it at the Denny's at Oracle and River, John and I, and had a payout. We bonded it out. Prudential bond got us a bond, 10% interest. I have a copy of the certificate in my office, but I never. But by the time I said, "Can I buy one of those bonds?" They're sold. And it was and then they refinanced it, and they're still, so that was the city of South Tucson. He got paid. Michael might tell you, we had a party, a celebration party at one of the, I don't know what restaurant it was on the south side, and Michael and I were the honored guests, and he was there. The plaintiff was there. His lawyers weren't there, but at that time. And then there was a little dispute over the fees. Bilby complained, Strike Lang had charged $120 for copying, and Bilby, and the explanation of the fees was, Bilby said to him, "What is everybody charging?" "Well, we're charging 50%. And here's what the federal judge's response: "You're charging 50% of this paraplegic recovery? How do you get there?" Well, the plaintiff's lawyer got a third. There was an appeal, and that made it to 40%. And we're the bankruptcy lawyers, and we're kind of getting 10%. And he was kind of interesting. And of course, I was licking my chops, really. And he said, "Well, I'll take a look at it," but he never did. And I don't know what the ultimate arrangement was. Michael, you started.
As Lowell said, the way the settlement was funded was by the city of South Tucson issuing new revenue bonds. And we used to go down to the largest industry in South Tucson, the underwriters of the revenue bonds, which was the grading of the dog. And that was how most of the tax dollars were going to be generated in the underwriters. Make sure that there would be enough handle at the dog track so that they fund the
So I'm not sure, we're going to talk about the future of where all of us are in another phase of this. in that case, it was not a very serious political problem filing the 9 because how it came up. I think for most cities, it's become a serious political problem. I see in the San Bernardino case, which I would have thought there was an order file, and then I read the other day, the judge never entered, I thought it would be automatically entered. He has appointed the lady from Portland, Liz Parrish, to bankruptcy judge to mediate the case between whoever their creditors and all that. But I think you're going to see more. It is a very powerful tool for these cities, to stretch or reduce the interest to market. Michael and I did the Hammaker Jewish Nursing Home, which was a nonprofit, who had bonds, and that became a little more difficult because of the bond situation. We have also participated, and you may see this again. We represented Pinal County in. There are a whole bunch of water districts who just quit paying their taxes. They just stopped. And then when the county assessors started complaining about it, 2 9s were filed, and Jim Marler handled both of those, and it wound up to be basically a stretch. The district court didn't involve themselves in it at all. They just sent it right to the bankruptcy judge. And all of your jurisdictional questions that we've talked about, close your ears, Judge. We just ignored them. We just went on with them. And it was get to a solution, and nobody fussed or raised hell because the bondholders said, we're not going to fight with you. Just get us some money and get it done in a manner. So, but it is a pretty powerful tool if you're against creditors.
Let me add a footnote to that. Larry King, for the Commission on the Bankruptcy Laws, and actually for Congress, accelerated the work on the municipal adjustment statute, because the great concern at that time in the mid to a little later 70s was that New York City would file. And he wanted to have a good statutory format in place. And it did get passed ahead of the Reform Act. I think it was in 1977, maybe 76. So he did accomplish that, and that was rushed through by Congress.
Let me shift the focus, Jerry. There's a case that sounds very innocent from the 70s, White Fence Farms. Those of you who follow the Arizona real estate market, ever since I've been around, you've had the Wolfswinkel brothers, Conley, Darrell, Clifford. There's a fourth one whose name escapes me. And it's been my sense in my time that if some Wolfswinkel wasn't suing another Wolfswinkel somewhere in Arizona, it was a very odd and unusual years. And at least to my knowledge, that started with White Fence Farms. So, Jerry, what was that about?
Well, Conley and Darrell and their older brother Clifford owned the entity. Clifford and Conley had 44+%, and Darrell had a smaller percentage. There were fundamental disagreements over certain investments and how to handle them and who was really in control. Clifford was the older brother, very domineering, strong personality. So was Conley. And what they got to fighting about was control. Well, control rested with Darrell and Conley as long as Darrell and Conley got along, and Clifford was outvoted. So Clifford went to Henry Jacobowitz to file an involuntary petition. Now, why in the world they did that?
This is called brotherly love.
It escapes me, but they were doing fine. They did have some unpaid obligations, as they always do, but there really was no need for Chapter 11 to be filed. Now, this was just after the new bankruptcy code had come into position. Hugh Caldwell was assigned to the case and set in Phoenix through the entire time of that case. And what I did was take in at the very beginning a consent to adjudication and an operating order like we had used in the old format under the prior Bankruptcy Act. And Hugh Caldwell signed both of those ex parte, as he should have done. We gave them what they wanted. Conley was president. We didn't even have to have a board meeting. And he was named in the operating order. The operating order had a number of provisions that were protective of everybody's interest, requiring notice, requiring consent, requiring authority from the court to do things. We took 21 propositions in a relatively short period of time. That was when Arizona was really booming. They were turning all of the farmland into buildings and things, and there was a very active market. And we had 21 propositions, and every one of them was fought by Clifford. He had a new attorney at that point and was putting up a vigorous battle. They got to the end of the road, though. Conley kind of overreached on one. A little squeamish. Squeamish.
Are you sure?
Yeah, but in any event, I did submit it, and Caldwell denied it. So we decided it was time to fold the tent and conclude this matter. And they had $100 million in cash or assets that was really solid. And they had gone into that proceeding with needing to do some things, and they got them done. And the problem was they were stalemated outside of bankruptcy, and Clifford really opened the door to a very creative solution, but he fought it every inch of the way. He just couldn't stand it. And it turned out they were really ultimately fighting about a diamond ring and a Mercedes.
I know all about that diamond ring.
In any event, and I think, did you give them the materials on the on this arbitration?
I did not. I didn't think that should go public.
Any event, they worked through everything, and they got down to Clifford was asserting a final claim, a little less than $1 million, as I recall, and he said, "Conley, you can arbitrate it. You be the arbitrator. I'm going to submit my position to you," and I couldn't believe this was happening. I sat around this huge table out at it was on the kind of southeast side. They built a new hotel out there in some of the land they'd sold. I forget the details and the name of the hotel, but there was this huge table, and we were all sitting around that, and Clifford put on his case. Conley listened to him patiently, had a recess, came back in, said, "Clifford, I'm ruling against you." So that was the end of the matter. And I can't say they all lived happily ever after, but they did get a lot of money.
Well, as I said, my view has always been that one of them is suing some of the other ones someplace, sometime. So if we go into the 1980s, you've got American Continental and Charlie Keating, which at the time was the biggest bankruptcy case ever filed.
We, by the way, were local counsel in that, but had to bow out because we weren't disinterested. And I don't remember the details of that. And I think then, as a result of that, who was it took over?
The judge or the attorney?
The attorneys, the local counsel. I should remember, but
Before or after there, do you see your work? They brought in counsel from LA.
Yeah.
They brought in counsel from LA.
Yeah, somebody from L.A.
There was a kid named,
Yeah, I'm trying to think of his name.
Mick got disqualified, and they brought in a group from LA.
but they did have someone local. Was it Salerno?
That was a lawyer's relief case.
Yes, it was.
Yeah. Now, to me, to kind of go back to the Wolfswinkel plan, the biggest borrower from Lincoln Savings, Charlie Keating's then S&L, was Conley Wolfswinkel and his company. And you know, the RTC started showing up in about 1988. I go on the bench in March of 1990, and if I remember correctly, it's 1991, a very large case gets filed by Mesh, Clark, and Rothschild in Tucson on behalf of Conley Wolf Swinkle and WGI. And as I said before, obviously they filed in Tucson because Judge Ollison's there. So in those days, let me finish. Let me finish. You have your view of that, I have mine. So in those days, you would physically walk the petition in, and there were little names in a cup, kind of like one of the little games we played as kids, and a name would be pulled out of the cup, and that was your assigned judge. Well, the petition's filed, they pull the name out of the cup, and they're told, you've drawn Judge Baum. And I was told by the people at the front desk that the response to that was, that cannot be right.
So we have another, before we had computers, you know that thing that you shake up and people play dice with? So they had 3 judges in Phoenix, and Judge Caldwell and I guess whatever the overlap was. And his clerk and secretary had moved with him to Phoenix. And so I get this call one day, I was telling them at dinner, from John Westover. And John Westover says, there's going to be a hearing tomorrow, petition, and I've got $80,000 worth of fees coming, and John Dawson is challenging it, and I need some help. Will you fly up? So I said, sure. And John,
Fly up?
Yeah, I never drove those days.
Did you charge that to the estate?
There was no estate. My client was
Oh, okay.
my client was O'Connor Kavanaugh.
That was a really good law firm.
But at any rate, so
Shall we talk about the Harry Kavanaugh, John Flynn fight?
He was my classmate, and he and John Mesh were like brothers. So come up there. So I arrive, and they're talking about how the case is going to be done, and she shakes it up, and out comes 1 cube. There was only 1 cube in there, and it turns out to be Hugh. So anyway, we go, and Dawson, John looks at me and all that. We finally settled it. I don't know, for pretty close to what John was at. And we're driving back to the airport, and he said, "Oh, this is wonderful. You've got me this fee. It's very important to the firm. What do I owe you?" I said, just fix it. Pay my airplane fare. Tell me what. He said, "I'm going to send you a check for $20,000. I said nothing. I was a little taken back. By the time I got on the plane, got back to my office, there's a call for John Westover. He said, I think I was a little enthusiastic. He said, I think that's a little high. Would $5,000 do? Which I thought was 3 times about what I was entitled to anyhow. I said, that's fine. So that was the cubes. And how long did you clerk for him, Michael? For you? 1 year. In what year?
I started October 1st, 1978.
So I've got one more case that I'm going to talk about, and then they're going to talk about others. And the reason that I picked these out has nothing to do with me personally or any of you. It was just the utilization that how we utilize the court, and that's Tucson Diocese.
Judge shopping,
No.
would you call it?
No, I didn't judge. We had a long. I said how you utilize the court to get a result, is what I meant.
Okay.
I hope that comes on the video correctly. I had for a long time had a friendship with a lawyer by the name of Tom Murphy, whose father had represented the diocese for 40, 50 years. Tom now is, I think, at Gus Rosenfeld. He'd gone, but he represented the diocese as an outside counsel. And the diocese had, among other things, had decided to not invest, $20 million to create a television station to spread the message, and they had engaged themselves and contracted with film producers so they had product to sell. They had the financial Monsignor was very aggressive in his business side of that. So that became a problem. We couldn't pay it, and we had big debts. The diocese had big debts. And then we finally negotiated with, we went and met a number of the cardinal, who's now a cardinal, from Los Angeles. They had a committee. And I remember traveling with the bishop, and he's reading his missal, and I'm worried how I can put numbers together, and he's praying, which I thought was a help, as a matter of fact. So we got there, and they wanted to know what schnook entered this business deal. And I said, not me. And we had hocked the cemetery, and it was just a total mess. Finally, we got worked out with, and they were very cooperative. And then we got a notice from, I don't know what Lynn Cadigan's partner was, a claim of this child abuse. And somehow we got into the fact situation that rather than filing the lawsuits, we would have a mediation. And when we arrived at the mediation, there were like 14 cases that they had, that they presented. And ultimately, for better or for worse, at that time we were kind of, the diocese was changing bishops from Bishop Moreno to the current bishop, who's a spectacular, honest, nice guy. I once said to him, did you know when you were coming to Tucson you were going to be facing this horrible event? And his answer, and as a soldier that he was, he said, what choice did I have? I came here to do my job. So we settled that in a mediation, probably, well, it was no secret, about $1 million a copy for the 14. At which point, and of course those are supposed to be all the cases, about 2 weeks later I got a claim for one of them, for somebody that Taylor wound up knowing very, very well, and a long thing asking for some $6 million for this event. This man, who ultimately became chairman of the Tort Victim Committee, I think he took $500 or $600. He was a CPA, a very reasonable, interesting guy, and a lot of the case revolved around repressed memory, statute of limitations, a lot of issues. Constitutional issues, separation of church and state. And so they filed. Susan Boswell filed it. She had been in the periphery of it with Michael and I. And we were gone. Somehow, we thought. Somehow we had been sophisticatedly fired. I mean, that's how I took it. Till we got a call from Susan and the bishop saying, come back, we want you to represent the 76 parishes. Well, the truth of the matter is, in my view, the value of the churches, the assembly halls, the schools, under Michael and my theory, was there. Because by that time, the diocese was hopelessly insolvent for themselves. They really didn't have any money that the parishioners didn't send them. While that was going on, Spokane filed. And the judge who you knew listened to all of this and said, well, it's obvious, all the parishes own the money. This is all one. One of the weaknesses in our, well, I won't concede it was ever a weakness, was that we had sent all of our money downtown to the diocese, and they mixed it up and spent it and didn't steal it, all that, but they were doing a central banking is their thought. Michael and I position is they were trustees holding our money. We didn't have any documents that said that, but that's what we thought we were sending the money about. The case had to have a solution. So we had so they formed a tort victim committee of which that chapter was a fight over, I can't remember the lawyer's name from Los. That chapter was who would have that committee and how much money they would make, and the same thing we all go through with relation to, what was it? What was it? Yeah, he had all of those. At any rate, so let me tell you now, because where you're all getting the inside of, you're getting the inside of it. Taylor devised a plan of kind of measuring, and I don't want to be gross about it. It was the degree of abuse. I guess if you got pat on the tush, that didn't worth as much as sodomy or whatever else was going on. But it was a situation to be done. And a couple of them were done, and the diocese had all kinds of property that had been donated to them. I mean, lots of property, almost 54 pieces of property. And the judgment was made by them to sell it and create a fund to pay for, and this is my words, pay for the sin and the crime. And a master was appointed by Judge Marler, a woman who had been a Superior Court judge by the name of Elena Rodriguez. And she would have hearings. Well, of course, she had to go through every prisoner at Florence who had read the paper and decided that the reason he was in prison was because some priest had abused him when he was 12, and by this time he was like 60. So it was very, very complicated, much to the credit of Taylor and his committee. That part was resolved. But I will tell you two stories about it. We were at the Arizona Inn. I had lost a watch that had been given to me for some honor, and I was bitching and complaining about that. And McGrath's on one side of the table, and the two sweethearts were there, Ashworth and McGrath. And Ashworth is trying to leverage more money out of us, and I'm saying we're innocent, all our parishioners just happen to be around, we're also victims and all that. And he said some snotty thing, all that, to which McGrath gets up in his usual calm way, and I said, we're leaving. And I said, I lost my watch and I'm upset, and I'm now wearing, I will tell you. So Taylor throws this watch at me and says, if you don't have a watch here, you can have that. Talking about the club that we all belong to, the necessity for coming to solutions, notwithstanding tough problems. So I have it engraved, Taylor to LAR. It was the date of that. We settled it very shortly after that. We took the two tempers out of the room, and so there was an ultimate result. Let me tell you, interesting about Miss Boswell's plan. Thereafter, she became kind of a national star, knowing about it. And she and Judge Marler, I thought he might be here today, went around on a tour and told about it and all that. Then she went to San Diego as consul for San Diego and got her brains knocked out. Just really, really beat up. Judge Adler was having none of a solution. She was going to punish that diocese if they stood on their head. And so that's the way that went. We then represented Riverside. I guess we were paired, Michael. Michael represented Riverside, and then it went on and on. I see now they're doing a mediation in Iowa. But I want to tell you, two things happened. One, the bishop, we had a statute of limitations problem. They had, the plaintiffs. The bishop said, if in fact it was proved that a priest molested somebody, I don't care about the statute of limitations. They're to get $15,000, even if they can't collect. So they had pretty much documented all of it. Do you remember that?
I remember I kept telling the bishop, you're going to pay some sum of $10,000, $20,000 to anybody that was abused. Regardless of the statute of limitations, there's no way for them to do a obligation. Obviously,
It was an interesting case. You know, you see the end of the cases, and you see that they end, and then the publicity about it, and even the lawyers don't know anything about it. But we were sitting in a meeting, Michael and I, with Boswell, and they had insurance coverage. We actually hired an obituary insurance guy because some of these events had occurred 20, 30 years before that to find the insurance coverage. So I'm sitting there minding my own business, ha ha ha, and I say, how much money are you getting, Susan, from the insurance company? I'm not going to tell you, because she's trying to negotiate more money out of Michael and I from the parishes. I said, what do you mean you're not going to tell us? We're on the policy. How do you get a release without us? Oh, and the bishop's getting very upset with me. And he said, you're yelling at my lawyer. I said, yeah, she needs to be yelled at. So we get all finished with the case, which I thought was an impossible case to have a real solution, but it ended, and I remember going to some funeral masses for some friends of mine, and I walked out and I said to Ann, I said, this place is going to be here after this case. I mean, it's been here for 4,000 or 5,000 years, right or wrong. This diocese is going to survive, and it was important to people. So if you want to know why I think bankruptcy is important. At any rate, so then we had a dinner. The bishop had a dinner, and he invited Taylor, and he invited us and all that, and we went to his home. And I'll remember it. He got up and he said, this is not a victory celebration. This is a appreciation for the lawyers that helped us. He said, because it was a horrible crime and a sin. And then we went on, had our wine, and did something else. So all of you have been involved in all of these things and have been exposed. But that was a magnificent utilization of what you do professionally. In my judgment, it never solved 100%, but it took a big chunk out of a lot of people and effort, and it was a whole team of lawyers. The last story about this case is I went to see Judge Marler at the request of my colleagues on both sides, and they said, why don't you go talk to him and tell him what a good job you think he did. So I go tripping up there, and he said two things. He said, well, one thing, we never really got to the issue, did we, Lowell? He said, you and McGrath hid. So I said, yeah. And he said, but you know what? The case would have never gotten to it in the solution if I didn't have good lawyers. So I was personally proud of my colleagues. So that's the three I wanted to talk about.
I'm going to tell you two stories of the 1990s that will always stick with me. I mentioned that Lowell's firm filed the WGI case. This was the days of the RTC, and all the S&Ls in Arizona had failed. The RTC now owned all the assets. And because Conley Wolfswinkel and his company were Charlie Keating, the biggest borrower, they were public enemy number one, to be blunt about it. So there was a big piece of property up near Oracle. I don't know how many acres, but it's now got all these homes on it. There's the Rancho Vistoso golf course, the Stone Canyon golf course,
I used to hunt quail out there.
a couple other golf
I
courses.
can't understand why.
The-
Did you ever pay a greens fee?
No, before they put anything in. It was that recent history.
Well, the RTC wants stay relief. There's a big fight about it, and I'm appointed a trustee, and at that time, lawyer Chuck Case is representing the trustee. And after a lot of hearings, I finally told the RTC, I said, you know, I'm not going to give you stay relief. Let's auction the property and see what it's really worth. And I did that in part because they had about 3 appraisals that said it was worth, the round numbers, $12 million, and the other side numbers were dramatically different. So we get to the auction, and it's the most outrageous auction I've ever witnessed as a lawyer or a judge. there's so many people there that the courtroom is so full that you've got bidder groups sitting in the witness stand in that area. You got other bidder groups over there next to the courtroom deputy in the well where people usually can't go. It's packed with people. To cut to the heart of the auction, I believe there were 4 or 5 bids over $30 million cash. And I think it sold for almost $40 million cash.
Tell them who it was sold to.
To Conley Wolfswinkel, who was the principal and the debtor. And for Conley to be able to bid, there was a big fight about whether he could be able to bid or not. And going in, you had to put up $1 million deposit to be able to bid. So I let him go back and forth a fight for a while, and I finally just ruled to end it. I said, you know, he has to put up $2 million, and if he does, he can bid. I don't care what you say, RTC. So he puts up his $2 million. And when he comes in with what I'm going to call an entourage. Everybody know who Danny Ainge is? Comes in with Danny Ainge, comes in with Chuck Fairbanks, who had been the football coach at Oklahoma and Colorado, and I think had at least one national championship. And I don't know how many people from Germany. And it was the classic auction because there are all these bidders, but every time it looked like it was about to be over, Mr. Wolfswinkel would raise the bid by another $1 million or so and bought that property. But at some point over the course of the auction, John Dawson, those of you who know, John was not a quiet character in court proceedings. And he had the stalking horse bid, then Del Webb Home Building Company. And it just was getting beyond them very quickly. And John, as John was wont to do, would start objecting about this part of it, want to comment about this part, want to be clear about this. And, even with that crowded of a courtroom, at some point, John is now back up at the podium about to say something. And Danny Ainge and Conley Wolfswinkel are rolling to my right, and you hear Danny Ainge say in a voice way too loud, "I'm getting really sick of this baby Huey guy." And if you knew Ed Davis, the old bankruptcy referee and bankruptcy judge we talked about, Ed was a real character, and he had a nickname for everybody, and his nickname for John Dawson was Baby Huey. So it was real hard for me, and I think most of the courtroom who kind of knew that, to try and keep a straight face through that. But it was an amazing auction, and it's the one, those of you who've heard this from me, this is kind of where it came from. Appraisers have their job to do. They have opinions about value. If you want to find out what something's really worth, put it on the auction block and see what somebody will pay for it. The other war story out of the 1990s I want to share with you is, this has to be, I got sworn in March of 1990, so this is probably late 89, it might even have been January, February 90. I'd been doing a lot of work in Yuma, so I was down there once a month down there. Mo Allison, who we talked about, was the judge. I think I'm having breakfast or lunch with Mo before or after court. And there was another RTC SNL debtor, Randall Jenkins, in Tucson. And he had about 10 cases, a lot of property, and I represented 4 or 5 banks in that. And my bankers were just livid because this is part of the heyday of the U of A basketball team. And Randall Jenkins had 4 seats in row 2 right behind the U of A bench. So every game, Randall Jenkins would parade in with his family or somebody and kind of his entourage and sit in those seats. My poor bankers, who he owed millions to, were sitting up, in row 55, kind of with their magnifying glasses trying to see where the court was. So I'm sitting there with Mo, and I'm going to be sworn in a couple of months. I said, Mo, I probably shouldn't say this, but what are you going to do about Randall Jenkins and his basketball team? He goes, what are you talking about? And I explained the story to him. He didn't say anything, so I figured, nothing's going to happen. So I don't think I've been sworn in yet, but this was just classic of Mo. You would get something in the mail, no return address, no signature, but it's an article from the Tucson Daily Star that says, Judge orders U of A basketball tickets to be sold. And those were the first 4 basketball tickets that were sold in probably about 91. And if I remember correctly, in the bid was just simply for the right to go to the university to buy the tickets. Those 4 tickets sold for about $25 million cash after some incredibly competitive bidding. Well, Mo then grabs me after I've gone on the bench and says, I'm entering an order appointing, is it Al Gamble, I think? Who was the Tucson law? Appointing Al Gamble to be the course administrator, and I'm ordering the University of Arizona Athletic Department to turn over the current and former ticket lists from the basketball program. And Mr. Gamble is to compare those names against the debtors list for like the last 10 years. Well, Mo knew, as only Mo could, that there were a lot of people who had been very successful in Tucson, who now had gone through bankruptcy, but had season tickets to the U of A basketball games. And for about the next 4 years, about every 90 days or so, we would auction off 2, 4, 6 U of A basketball tickets. And it was like a feeding frenzy with a bunch of sharks with, I mean, red meat in the water. The competitive bidding for those was just amazing. And they would sell for about $10,000 or more for the right to go buy the ticket. And that went on for about 4 or 5, maybe 6 years. And then in the materials is the site to the In re Herald decision by the Ninth Circuit out of the Lewis and Roca firm that said Phoenix Suns basketball tickets, there was no right to the future tickets. It was
They're
a mere,
licenses.
it's a mere expectancy. And that was the end of the U of A tickets. But for about 4 or 5 years, it was a very wild process.
I was not responsible for that case.
I thought you were the head of that firm, but never mind. You know, there's a case called Boston Chicken, Jerry, that I think you had some role in. What was Boston Chicken all about?
I can't talk about it, it's still pending. This goes back to 1998, and counsel from Texas were going to file a Chapter 11 case, and they decided to file it in Arizona, and Judge Case was the judge, and because I had started him in bankruptcy and we were pretty close, I always disqualified myself from any case where he was involved, basically at his request. So I introduced all the players at the first meeting and then said, in accordance with your request, I will no longer participate in this case. Don Gaffney did a marvelous job defeating for Sherman Sterling a preference attack. Very interesting case. If you ever get a really difficult preference matter, Don can help you.
I will tell my judicial story related to the case. In the early stage of the case, I was local counsel was trying to flash and the proof were medically bidding. And the day the case filed, it was a pre-pack but there was subsequent litigation where they were trying to basically cash out most of the debt. There was some litigation that was filed. And by this time, we're going to leave the office. So we ended up with some discovery. So Stinson from Carroll.
I turned out to be your star witness.
And they told me I had to come look at the documents, but I had to go on Saturday morning to shut off the irrigation. I stayed there for 14 hours and all the associates left. And I found a document which included a long discussion of their views of Judge Case. It was also shared with people who were not lawyers. And I thought this something that I wanted to produce. Well, they were all upset when they got it. I said, that's fine. We'll submit it to Judge Cameron to decide. And we submitted it to Cameron. They settled the case the next month.
You had a piggyback in the case later on.
The case was confirmed and provided for a liquidation trust in 2002, and I became the trustee and hired Leo Buse, and I forget the figure, we recovered,
It was $345 million.
I think it's a little more than that.
Yeah.
Any event, it helped Leo out considerably, and and I told him when I went
Say the
in,
least.
I will set my fee at an hourly rate of $350, and I've never moved it. So Louis and Roca didn't do real well out of it, but certainly Buse did. And by an odd circumstance, Arthur Anderson was on its last legs at the time. And they gave me confidential information to look at in deciding whether to settle. And I can't even mention the amount for which we settled, but I looked at it and concluded, yes, they're doing the best they can, and that kept them from filing a bankruptcy proceeding, my agreeing to accept that. And we were the last one, and that allowed the case to be put to bed as far as Arthur Anderson. So that was an interesting sidelight about it. But we did pretty well. Leo, very good.
There's another story in that case with personalities that you can't let go untold. That's one of those plans where you want to be careful about what you require the plan trustee to do. Because Jerry was appointed as plan trustee, liquidating trustee, whatever it's called. But it basically required him to look at just about everything in the case. I mean, claims, whatever there was, but it included all the professional fees. Well, you already mentioned that the case was heard by Judge Case, who then is his former partner. And most of the large part of the case was done by Randy Haynes, who by the time the plan is confirmed, is now Judge Haynes. Well, the plan is confirmed, Jerry's required to look at everything, including all the professional fee allocations. Well, he notes that that case was filed, I don't know, 6 in the morning or whatever it was, before the markets opened. And now Judge Haynes cannot bill and set off all of his time, pre-petition time, before, at 6 in the morning, before the case was filed. So he duly objects that Judge Haynes had pre-petition time included in his fee application, to which Susan Freeman, on behalf of Louis Roca, responds and indicates that he was working all night, and of course there was time he couldn't set it up. I might have suggested to Ms. Freeman that it was a guilty objection, and that she should have sought sanctions, but she didn't think that was appropriate. Judge Case had no trouble overruling your objection to Judge Haynes' time.
Well, I'd forgotten about that. Any event, you can be in an awkward situation every once in a while when you're a trustee. And that was one of them.
Now, let me shift the focus to another set of cases, Lowell, that you were involved in now. In the 1980s, the Sabin family filed a bunch of bankruptcy cases, and the Sabin family was the first U-Haul dealer for the U-Haul company. And their biggest creditor were a lot of the members of the Schoen family who owned the U-Haul company. Well, if you followed it, there was tremendous litigation between that family. The founder of U-Haul, L.S. Schoen, I think had about 15 children with 4 or 5 different wives. And I was the settlement judge when I was finished with them, and it didn't settle during my tenure. I said, I guess they don't get together for Thanksgiving anymore. And that was being incredibly diplomatic. I'll never forget going, one side of the family gets about, I think maybe a $2 billion judgment in round numbers.
I'll tell you about the judgment.
Well, let me say one more thing, then I'm going to hand it off to you. So it's Judge Marler's case. I'm appointed to be the settlement judge, and I set a scheduling hearing to get them together. And the first thing I'm told by the lawyers is they will not meet in the same building. So, well, you know, that's going to be a little awkward because I'll have to leave building A and go somewhere to building B, and that seems a little counterproductive. So I said, can't we work it out where we'll put, you know, one plan on one floor and agree that nobody else can go on that floor and we'll get another floor? Okay, so we do that. So I'm going to have a preliminary meeting with the 5 debtors. There's 3 Schoens and 2 officers of U-Haul. and Lowell represents one of them.
Hap Carty.
And I can't remember all the lawyers, the other one. So I go to a meeting, I think, in the Moore Hackett Law Firm conference room. And when I go in, I'm thinking 5 debtors, okay, I'm going to have, 5 to 8 lawyers there. There were so many people in that room, if I counted correctly, not counting me, not counting the debtors, I think there was almost 30 other people in that room. The 5 debtors, I think, had about 8 different law firms and 7 different accounting firms. And you're just sitting here going, this probably isn't going to go real easy. So Lowell, maybe you can share a little bit with us about the shown debtors, the bankruptcies, and that process.
Well, basically, that was a strike land case. Dawson and Boswell did it. And I was hired by Hap Carty. Hap Carty was the brother-in-law of the Schoen that finally, and Hap had invented the hitch that you do when you're at the U-Haul. He was the one that did that. And he came to my office and he said, I've just gotten a judgment against me for $1 billion. I said, pardon me? I've represented people who owe a lot of money, but I've never represented anybody. And he, very nice, outstanding guy. Had a tattoo, and he was wearing a U-Haul black T-shirt. And he was a very simple, nice guy. And he said, well, what difference does it make if I have a judgment for $1 billion? I don't have that kind of money. It really doesn't make any difference. So it was in the Superior Court, and they had hearings and all that, and the judgment was reduced to $1,400,000. And so I went home and I said to Ann, God, did we get a break? Did we get a break in this case? It went from $1 billion, or whatever the number was, to $1.4 million, to which my wife said to me, is there a difference? What difference does it make? That case went on for a couple of years. It basically, a plan was filed to give these people, Taylor represented one of those families, to give these people the indubitable equivalent. We were going to give them this land in Iowa and this land in California and all of this and some money. There were the 3 different kids, 3 of them, 3 groups. And they took depositions, so it was coming out of years. They went all over. One of the depositions was of Mr. Schoen, the father. And it was in Las Vegas, and Boswell and Hollowell go. Hollowell was at Mesh Clark and Rostow at that time. And she comes back and she says, why did you do this to me? I said, what are you talking about? She says, we get there and we're talking about it, and he's telling me what bright children he had. One was a lawyer, one was a doctor. The one that runs it was none of that, and very, very capable. That had been the second time the case had been filed. John had filed it once before in Chicago. They had a whole history. I said, why? He said, well, we're asking Mr. Schoen about this child and this child. And he said to Miss Boswell, Miss Hollowell, well, I guess you don't understand. I have special sperm. I said, he couldn't have said that to you. Well, she said, I'll get you the transcript and you can read it for yourself. So I said, oh, good. Unfortunately, I will tell you, he, ultimately committed suicide. And the company's very successful now. But yeah, we did this 1.5 years. I made a lot of money just reading strike lang pleadings for Hap Carty. And it was interesting because I filed an 11 for Carty because he was defendant. And I talked to you about it, Jerry. And they never sued the wife. They never got a judgment against the wife. They just got a judgment against him. So I said, what do I do? And Jerry said, well, just file for the husband. So if they're ignoring her, you ignore her. So that's how the case stood. They come to the confirmation hearing, elaborate confirmation hearing. There had been an early motion to dismiss, either by Taylor or somebody else. Somebody had filed a motion to dismiss. Millions and millions of dollars were spent. It was a lawyer's paradise. And Marler denied the confirmation. He said, you have to pay cash. That's the deal. You can't do it with an indubitable equivalent. So ultimately it was settled, one for $55 million, one for another 60 million. Who knows what it was? But then the case resolved itself.
I mean, the numbers were staggering. I can remember sitting there with one member of the children of their lawyer. And I don't remember the numbers exactly, but they basically were prepared to write a check for like $70 million to, if this daughter was over 30 at that point, I'd be
Well, none of them, of course, I'm going to show you my bias. None of them worked.
Why did they file?
What? What did they run?
Well, one period had Gallup in San Francisco. It was very nice work.
But the numbers were just staggering. I mean, this was probably about 1995, and you're talking about $70 million. Now, I don't know about you all, but I think, if you gave me $10 million, I could live extremely comfortably for the rest of my life.
I bet I can negotiate a lower number.
I bet you can. It was just mind-boggling, and then, of course, the judgment debtors were the ones who owned the company and still own the company. And
Because of the judgment.
Lord only knows what they're getting. It's about 11:20, so why don't we take a second break for about 10 minutes, and then we'll
Wrap
spend
up.
1 more hour and wrap up.
So you all get credit. Oh, it was. He let them do all of this, but the plan was there on his table for a year. And he could have dismissed it out and said that he didn't. They put on the proof, and he said, "This requires cash."
AC in here has an on or an off switch.
Interesting.
Apparently it's on.
That was in early. How long do we go? 12:30
12:30.
or a little bit?
Word.
Michael wants us to talk about Fort Defiance. He said,
All right, we're going to start it up again. Last about 45 minutes plus or minus. Over the break, Mr. McGrath asked us to talk about a very unusual Chapter 11 case, Fort Defiance Housing Corporation, which was a government-funded building of housing units on the Navajo Reservation. I think the total funding was in excess of $100 million, and there was a lot of construction up on the reservation, but one day dropped into my courtroom this case, and it was initially filed by a solo practitioner, I'm going to say from Gallup, New Mexico. I'm not exactly sure if I have the town right. But it became very apparent very quickly that he didn't know his way around the bankruptcy court. In fact, I think I had to remind him a couple of times he needed to file an application and an affidavit to be appointed. And, it just was one of those cases where nothing was going right, so very quickly I ordered that a trustee be appointed, and my soon-to-be colleague, Brenda Wintery, was the trustee. And it was a wild case. I know at some point, I don't think I ordered, but I strongly suggested that Brenda should make sure that she visited all the sites, because there are all these remote locations in northern Arizona on the Navajo Reservation. And it was really a mess, because the money had gone through, the $100 million in round numbers had gone through Fort Defiance, who had hired two people, Bill Aubrey and Brenda Todd, and their company to actually build these housing units. And there were a lot of issues with the appropriateness of the building, but more importantly, a lot of things didn't happen that were supposed to, And in a simple sense, and I don't remember the numbers exactly, but I'm going to say in round numbers, about 75 million actually went into the housing units. And the other 25 million, it was a little fuzzy about where it went, but Mr. Aubrey and Miss Todd, who at one time were living together, seemed to be flying very high. I think there were airplanes and cars and trips and casino gamblings. And they managed to take a lot of the people who were making the decisions at Fort Defiance and on the for the Navajo tribe seemed to be guested there someplace. And the trustee files a lawsuit against these two. And it's basically, in a cryptic sense, for taking this money that should have gone into the housing and sticking it on their own pocket. And it was a very interesting trial. If I remember correctly, Brendan, you tell me if I'm way off. I'm going to say the exhibit books were probably more than 10 feet long, probably closer to 15 to 20 feet long. And you know, when you have these multiple entities and it's HUD money and government forms, what was the word? NAHASDA, something regulations about how you had to do the construction. Lori represented one of the main lenders. And when the adversary was all over, I entered a judgment against them for, in round numbers, about $18 million punitive damages. And I don't know the whole story thereafter, or maybe Brenda or the successor trustee, Lowell Rothschild, when Brenda becomes sworn in. They've gone up to Las Vegas. They filed Chapter 11s there. There are still appeals floating around somewhere at the Ninth Circuit about something, but it was an amazingly unique case. And the one thing it really illustrates to me is that Chapter 11 is not perfect, but it does provide a mechanism for troubled financial entities, whether it's General Motors, whether it's Fort Defiance, whether it's the Shones, Bashes, or whomever, to have an opportunity to try and deal with those as opposed to being kind of dismembered in any kind of state court proceeding. And at least to me, sometimes I think when we get into the nits and gnats of the battles of individual cases, you kind of forget that basic premise. That's really what it's there for. That's what it's all about. And in my sense, again, it's not perfect, but generally it works. And it allows a lot of businesses, a lot of jobs, a lot of industries to be there. Think about it. No Chapter 11, no Bashes, no now U.S. Airways, on and on and on. Now, Brenda, I don't know if there's anything you want to add about Fort Defiance.
Fort Defiance, I mean, there were 650 affordable housing units. That's really the only housing on down in the nation. It's a big chunk of their housing. The NHA also has housing. We restructured it so it's actually a consensual plan with HUD, USDA, and private owners so that we maintain the housing and we paid off all of the creditors in the case except NHA, who were negotiating the final settlement. I actually have hopefully have it wrapped up.
You know, I'm always optimistic about those things, but I've worked for the federal government for a long time.
Okay, you may have a successor.
Don?
I do want to realize that I probably outnumber the members of here, but there is always struck me the fact that people can refer to Chapter 11 as being successful in terms of the organization plan. And that's true in some cases, but not always. And I would offer the other thing, which we see a lot more, as I can obviously do with federal employees. It's become the primary court for dealing with significant frauds in this country. You probably, the bankruptcy courts handle probably, I would guess, 78% of the major fraud cases in the United States. And, yeah, let's not get indicted here.
Except when it's a bank that's doing the fraud.
We call that preserving the
Which, by the way, from a dollar point of view, clearly overwhelms everything in life.
I was also going to get your name correct.
What's the level? What? What's the level? What do you want to read?
What? Yes.
Well, I have one now.
mortgages limited, you go through a long list of products.
Well, you mentioned Ned Warren, so I'm going to share this story with all of you. I told at dinner last night when we prepared for this program. For those of you who don't know, Ned Warren was kind of the Charlie Keating of the late 1960s and early 1970s in Arizona. And I'm going to have to admit that Ned Warren's law firm was Rollins, Ellis, Burrs, and Kiewit, where among others Tom Baum and Jim Marler practiced law. And as things kept getting darker and darker for Ned Warren, in my view, our best client, Valley Bank, comes up one day and says, you know, you guys are really good lawyers and we really like you. And we'd like you to be our lawyers going forward. But we've come to the conclusion that you can either represent Ned Warren or Valley National Bank. Take your choice. And it was a very difficult choice because in about 30 seconds we said to Ned, you know, maybe you ought to get another lawyer. You know, apropos to what Don said, I look at it, I think essentially the same way, but I call the bankruptcy court the court of last resort. Because nobody goes to the bankruptcy court as their first solution to whatever their economic or other problem is. You try everything
Nor
else.
should they. Nor should they.
I'm not saying they should, but what I'm saying is when everything else has failed and there is no other solution, whether you're General Motors or I'm going to mention a couple of good clients of mine, John and Elizabeth Tucker, and everybody in between, you go into Chapter 11. And that's your last resort, your last chance to save whether it's the auto industry or the family farm, Mortgages Limited, all the investments they made in all that real estate all over Arizona, American Continental, the same thing, et cetera, et cetera. It's the last shot. And sometimes it works, sometimes it doesn't, but it's the process that brings it to whatever conclusion it's going to come to.
So let me ask this question. So we're now in 2012. Some are wrestling with individual Chapter 11s. We now have, it's not a phenomenon, it's just that we have debt and guarantees. And we have before the Ninth Circuit an issue on where the guarantors are paying the debt. And Judge Marler has, the comments of the two of them were funny at dinner, has issued an injunction while the appeal is going on to let the, to stop really the lawsuit against the guarantors. So we've got, so what is the real future? I know you must think we're a little strange discussing this at dinner, but we were talking about, and it's going to come up, we were talking about some thinking now, and maybe you can talk about it, Jerry, of having a Chapter 11 and a half, 14, maybe it's a different 13, because the numbers are not, don't work anymore. You can have a condo in New York City and you're out of the jurisdiction of a Chapter 13, even if you would be otherwise eligible. So are we really, is the future now developing an ability for individuals, and I've read the Markel case and I know the disputes, which maybe you talked about in the next couple of days, but we've talked all about history, we've told our war stories, but we're kind of interested in where we're also going. You've got a new set of, for Arizona, you've got, going to have maybe 7 different new judges.
You are.
And a state that will continue to grow, a system where risk and entrepreneurialism is desired, frankly, in my judgment. What is the practice of bankruptcy going to be for protecting individuals who now are in a situation where they were guarantor and attempting to get the capital to develop the things that we need in the state, housing, institutions? You have a reaction to that.
Yes, a strong reaction. We really need to undo what was done in 2005, and we need to make it as to the individual, and make it so that an individual can have effective relief available. And one more war story. When the commission was getting to its final stages in the spring of 1973, we were all gathered around, everybody was there, we were going through the final motions to approve what had been done, and I had taken the commission's approach on the administrative side of it, which was to have the U.S. trustee basically, I don't know that we called him U.S. trustee, maybe we did, I can't even remember that. But we got to that point, and I had done something in the individual context, using the administrator to approve what he was going to be spending. And Seligson, who had handled Mike Todd's case, the producer of Around the World in 80 Days, he said,
One of Elizabeth Taylor's husbands.
yeah. And he said, Smith, you viper, you've stabbed me in the back. And Countryman piped up and said, Charlie, you've mixed your metaphors. In any event, he felt so strongly about that, it kind of weakened our relationship, even after all that had happened over the years and for the last year. And I've always felt very sensitive about that. If there had been something like what came out of BAPSIPA for individuals mentioned, it would have really bothered him and I think everybody else.
So, Jerry, let me ask you a question. You know, you really are more of the philosopher about the bankruptcy than many of us, besides being an effective advocate. And for somebody who spent, I mean, you're pretty objective about it. You're really a switch hitter. You represent banks, or you did major things and all that. It sounds like you think, and I'm very sympathetic, I plead guilty, there ought to be more relief for people who have this debt and take this risk and do all that, than like 205 ultimately wound up. You're not a great believer in 205.
No, and you know where this all goes back to? There was a bankruptcy judge in Alabama in the 30s that when a straight bankruptcy was filed for an individual, he would not enter the discharge. He would suspend that, and if a certain amount was paid to creditors, then he would dismiss the case. This was the origin of Chapter 13. And Chapter 13, I've never been very fond of Chapter 13, frankly. But I think we're stuck with that. But to impose that then on an entrepreneur, an individual who, these people are risking everything to do things that are important to our economy. They're important to them too. They can be selfish about that. But to then make it so difficult for them to get any relief, it is a nightmare, the individual case with the 2005 BAPSIPA. I would eliminate all of that. I don't even know that I would have 13 if it were up to me, but I think we're probably stuck with that. But if we are stuck with the individual BAPSIPA provisions, we need to modify those, and we probably need to lift the maximum debt that can be that will allow you to file 13 and just get rid of the individual Chapter 11 case, or we need to have a separate chapter. And the National Bankruptcy Conference is working on that and have been working on that. The problem that came about is the credit card companies and the banks were paying so much money in lobbying. I think I used to use the figure 180 million. I saw 80 million mentioned by somebody. And the National Bankruptcy Conference didn't try to touch it, even though the legislation was pending. They could have done things to that legislation that would have made it at least livable, but they never did anything. And all of a sudden it passes, and it's a nightmare.
Well, let me share a couple of doom and gloom thoughts about all that with you. You may have remembered that I mentioned the president of the National Conference of Bankruptcy Judges scheduled to testify before the House Judiciary Committee about Stern versus Marshall, its impact, and some ways that Congress could think about dealing with that. Well, over the break, I was looking at my iPad and I got an email, and that hearing has been canceled and it has not been rescheduled. I've been told from a number of sources that I have a lot of faith in that there is no stomach in Congress today to even touch the bankruptcy code in any respect. There's not going to be any amendments presently, and I don't know when that might change, but it reminds me of something that Winston Churchill said about our country. It says, you can always count on America to do the right thing after it's tried everything else and that hasn't worked. And so my sense is, I hate to say this, but I think things are going to have to get worse in the bankruptcy world collectively before there's enough motivation in Congress to deal with this issue.
Well, if you look at that chart that Dale handed out of the evolution of the Bankruptcy Act, you can, at the bottom of it, and it's a very well done document, you can see the economic things that are happening. I've felt, or at least my observation for the last 6 decades is, and it hasn't in the last 10 years, but that's a political thing, that relief moves with the times. I mean, it's very, very clear. I mean, if you look historically, they had a bank, other than the Constitution says they will create one. They had an act or a code or whatever, and they've abandoned it sometimes. It depends on the times. So unfortunately, if our world gets worse economically, they're going to really be forced to be facing it. What I was interested in is I've always resented, frankly, and because I think it was decided on a morality basis, taking away the right to file a 7 straight out. I just think it corrupted what I thought was the bankruptcy. Right. And that's number one. Number two, our world economically it's like what I call California, the land of the misplaced decimal point. If you talk about $1,000 at one time, you're now talking, we've talked today about millions of dollars and $80 million, hundreds of million dollars. Well, in my lifetime, it's sort of like looking at a merry-go-round. And so the numbers have all changed, and I don't think that law which is important to me and to a lot of people in this room, has moved with it. Or I thought the 205 moved backwards. But it was very clear that that was a morality decision, or it was a lot of very influential banks and credit card companies.
Oh, what was one of that might be?
What did
You what?
I have a question for you. I think that the law said something I probably just don't count on you to change the statute. And that's not only is it not currently an attitude favorable to the legislative consideration, but there almost never is. So my question for you is, on the hand that the bankruptcy reform act of 1978 never gets passed. There were, in fact, that's the one act that you really can't associate particularly with a horrible economic condition. It was the embargo, and so the security market had gone down. There were some things, but that process in my opinion took a long time to get it passed. It got passed during a time where it didn't really have a bunch of crises and people all the time. So how did it ever get passed? And how did it just stay rational? Part of the bankruptcy reform Act was an unusually solid piece of legislation that didn't have a whole bunch of crap in it. So we got a whole bunch of crap in there now, but before the lobbyists got started paying and lost and praised and derivatives and all that other stuff. It was a simple code
Well, you had a great deal of work done, and it was in pretty good shape by the time it was being considered initially by Congress. And then Congress put a lot of effort into it. The Senate had its own version, and then the House, and you had really some excellent legislators. Don Edwards, you had for the House, you had Senator DeConcini, and I don't know, maybe the times were different. Yes, Don?
There was one event that did kind of pop up here and help a little bit, because normally you think banks would be digging their heels in a lot of stuff. I remember Levin made a question about the whole time they actually fund the prayers. But Pine Gate was in '74. And there were a lot of people upset about the Pine Gate decision to cram down to 12. And the lender community thought that they would get a better deal. And so they were relatively passive on the plan. They did not send a lobbyist out. Because they felt like the Pine Gate was getting fixed.
You know, I think Jerry hit on a point that to me is very apropos about, I think the times were different in the 70s. If you read Judge Munn's article that I've mentioned that's cited in the materials, there was a bipartisan effort and agreement, maybe not on the specifics, but that we need to do something. We need to pass a new law. The one we have isn't working. It was, if you read that article in entirety, and as Jerry said, it was signed in mid-November, very near the end of the term. It almost didn't happen, but a lot of people got behind it and pushed it. Well, I hate to get into the political world today, but I just don't think there's much bipartisanship going on right now in our country. And I'm not going to say one side or the other is right or wrong. I'm just saying it's collective. And so until you have some agreement in the political process, the chances of getting another bill enacted, I think, is extremely remote.
Or any bill.
Yeah, any bill. I mean, not just bankruptcy. I mean, I think Bernanke said yesterday to basically Congress and the President, if you don't solve the mandatory cuts that are coming, it's going to be catastrophic in terms of the effect on our economy. And that happens, I think, January 3rd of 2013. So it's less than 6 months away. There's no bill pending. There's no hearings about it. They're going to wait until after the election, so they're going to do that in the last 60 days before the deadline. What did Churchill say? I forgot again.
Well, I think we're finished.
Are there any questions? Let me maybe conclude by saying something about my two colleagues up here. How much I appreciate their times and their comments. It's obvious that we've talked about this today. The wealth of knowledge, history, and experience that they have. And I, for one, and I think all of us are very grateful that they took their time today to share it with us. So let's give them a round of applause.
Thank you.
You're a good moderator. You're a good folks.
Thank you. Thank you, Jerry.
Was that too personal?
You get personal?
But you did remind me